Yeah, no longer.
Wow.
So just while the recording is on, the board came out of executive session at 7:20, and there were no votes taken in that executive session.
We're recording again, anyway.
On the agenda is item number 4, new business. ZBA 2625, 3 West Road, Assessors Map 69 / Block 66 / Block 38, R10 zone. David Smalley applicant, Paul O'Donnell owner. After the fact variances, section 26.11.14 with record coverage, and section 26.11.8 for north side setback. This is to do business is to receive the application and schedule for public hearing.
Hi, buddy. Paul O'Donnell, owner of 3 West Road. Obviously, red, we're looking at after the fact variances. A little brief history on the house. We renovated it a little over 5 years ago. At the time, the zoning board approved everything. And unfortunately, FEMA got involved. We had to eliminate the 3rd story at that time. And we had to wait for 5 years, waited 5 years, and that's why we're back here. One of the reasons for the variances for the ground coverage in my builder here, Dave Smalley's here too. So, but one of the variances is the ground coverage. And to meet the new FEMA code, we had to raise the electrical box on the north side of the house. Raising the electrical box on the north side of the house, the electric company said we had to put in a set of stairs because I guess certain height you have to meet to work on the electrical box. So we had to pour a pad and build a whole set of stairs. In addition to that, we eliminated the oil and switched the heating system over to electric, and the portion of it is propane. So we had tape, and we had FEMA required us to pour a pad on the north side of the house, and we poured a pad that was actually going to strap down the tanks also. We have 1 tank in there right now, but it was poured for possibly 2 tanks in the future. So the ground coverage between the stairs and that kind of chewed it up to a little over 2% higher than what was originally approved because we had electric. We had to read electric specs.
Construction, that came back. They said, you have to raise the meter box and meter pad.
And then the other variance is the north side setback. I quite don't understand this one, to be honest. I hired the surveyor to come back and survey the property. North side setback was approved at the time, but I think when they approved it, something with the notes at the time of the zoning board.
I don't know if you want to wait until the public hearing to get into this more. Yeah.
Tonight, we are only considering whether to put this on the agenda for next month's meeting. So we will not be taking.
I thought this was like the approval.
No.
Wow.
I thought we were just going to give a couple of sentences. But, but we are just going to take a vote tonight to schedule this application for public hearing. To receive it, it's received tonight.
Okay.
The application is received, but it's to set this matter for public hearing at the next meeting of the Zoning Board of Appeals, which is June 17th. Thank you, on the 26th. So you will, of course, be welcome to present your case. If the board, moves to schedule this for public hearing. Okay.
What if you don't schedule a public hearing?
The next thing on the agenda will be to proceed to consider that. So you don't. So there's.
So we're all set there. I'm not pleading my case here. Come on.
In person.
All right, I guess then,
Thank you though, for stepping forward.
thank you very much, I appreciate it. Thank you.
So this matter is on the agenda for receipt, the application, which it has been received today. And I will entertain a motion to receive the application and schedule this matter for public hearing meeting. And I believe that staff has circulated a draft motion. Would somebody want to make that motion?
I'll make that motion.
Do you have a copy of that? Of the proposed motion to take a look at? If you would like to.
Kind of figure this one. I'll repeat that motion and
Please.
we have a public hearing on this gentleman.
Do you want to read
Yes,
it?
please read the motion.
Oh, I'm
Read
sorry.
it.
I'm so sorry. Move to receive application ZBA 26 5 for 3 West Road, Assessors Map 69 / Block 66 / Lot 38, Zone R-10. David Smalley is the applicant, Paul O'Donnell owner, for requested after the fact variances to section 26.11.14 to permit 35.2% ground coverage where 32.4% was previously granted and up to 15% is allowed. And section 26.11.8 to permit a 5.5-foot north side setback where 10 feet is required, and to schedule a public hearing for Wednesday, June 17, 2025.
Oh, it should say 26.
17.
26, should be
It
26.
should be 26, yeah. I'm not sure
Well,
how I
it's
got it here.
At 7 p.m. at the end of tomorrow, Town Hall 54 East Main Street.
Thank you. Is there a second on this?
I'll second the motion.
Thank you. Is there any discussion? All right, all those in favor of the motion to receive this application and schedule the matter for public hearing? All in favor? Any opposed? Any abstentions? All right, it's unanimous, the motion carries.
Thank you, gentlemen. Ladies and gentlemen, appreciate it.
Moving to next item on the agenda, which is old business. There are 3 applications that are noticed for public hearing tonight. And I'm asking Tom Schultz, our secretary, to read the legal notice of public hearing.
A legal notice of public hearing, Town of Clinton in the Town Hall in Rose Room. The Town of Clinton Zoning Board of Appeals will hold a public hearing on Wednesday, May 20th, 2026 at 7 p.m. in the Rose Room of the William Stanton Andrews Memorial Town Hall, 54 East Main Street, Clinton, Connecticut, to consider the following. ZBA 26-2 5 Short Grove Road, Assessors Map 69 / Block 70 / Lot 19, R15 Zone, David Seeger, applicant, Laura Seeger, owner. After the fact variance request to section 26.11.6 for the front west setback for the house and shed, and to section 26.11.8 for the south side setback for the shed. ZBA 26-3, 82 High Street. Assessors Map 44, Block 26, Lot 11, R20 Zone. Joe Wren, applicant. Chris Tennis on behalf of Gilead Community Services Incorporated, owner. After the fact request for variance for ground coverage to section 26.11.14. And then ZBA 26-4, 32 Old Nod Road, Assessors Map 20, Block 6, Lot 57, Zone R60. Robert and Brianna Godsey, owners. Brianna Godsey, applicant. Robert Godsey and Brianna Muscio Godsey, property owners, appeal of the April 2nd, 2026 cease and desist order issued by the zoning enforcement officer for violations to Town of Clinton planning and zoning regulations. Section 27.1.71, 12.53.3b, and 12.53.31. At said hearing, all persons will have the right to be heard and written communication received. The applications and accompanying maps and correspondence are available for public inspection on the town's website. Anyone requiring special accommodation to participate in the public meeting should contact the land use office at 860-669-6133. Laurie Jaffe, Chair, Town of Clinton ZBA. Email to Harbor News to appear 2 times on Thursday, May 7, 2026, and Thursday, May 14, 2026.
Thank you, Tom.
Yeah.
First item A, ZBA 26-2, 5 Shore Grove Road. I'm recusing myself from this application because I'm an abutter to the property. It's an issue in this application. Tom Schultz will be assuming the chairmanship for this application.
Wait. I'd like to ask Bruce King to be seated as an alternate for Laurie.
He was already seated for C. Walter.
Oh, he was already seated for Carol, so do we have any alternates left? John?
B. John.
John will be seated, so you'll have 5.
Yeah, I'm sorry.
John Whittle will be seated because
Okay.
since Carol's not here,
Okay,
Bruce is seated for Carol, so now we'll see John for Lori.
John will be seated. I'm going to briefly go through the public hearing procedures so that people are aware of different aspects of how we hear this hearing today. First, the applicant will present their application, then commission members can ask questions. If anyone would like to speak in favor of the application from the public, if anyone would like to speak in opposition to the application, if anyone would like to ask general questions about the application, when people from the public speak, they should state their name and address for the record. The applicant should respond to any of the comments or add any additional information. The commission members have any additional questions. The public, if anyone else wishes to speak. So we'll proceed with the hearing on. I'm sorry.
5 Shore Grove.
Yes, from 5 Shore Road, Grove Road. So who are the applicants?
I'm Lori Seeger. I'm the owner of the property. My husband David.
Yes.
Hi.
Yes.
Okay.
Yeah, please.
Okay. Good evening, Mr. Chairman and members of the Zoning Board of Appeals. For the record, my name is Lori Seeger. I'm the owner of 5 Shore Road, and this is my husband David. He's the applicant. We're before you this evening requesting after-the-fact variances for the front west setback related to our home and shed, and for the south side setback for the shed. First, I would like to clarify that the front setback variance for the house is very minimal. The structure extends approximately 18 inches into the required setback and is limited to the garage portion of
Could
the
you speak a little more slowly?
Sure.
please?
Yes.
Yes.
And maybe a little louder.
Okay. The structure extends approximately 18 inches into the required setback, and this is limited to the garage portion of the home. The structure is otherwise fully compliant and consistent with the surrounding neighborhood. This is an after-the-fact condition that was not intentional to circumvent zoning requirements. The structure was placed based on a reasonable understanding of the property layout. The encroachments are minimal in nature and do not affect neighbors or the character of the neighborhood. Requiring removal or relocation of the garage would impose a substantial burden while providing no corresponding public benefits given the negligible nature of the encroachment. With respect to the shed, it was placed close to the property lines if permitted due to the physical constraints of the property. When we purchased the house, the shed was initially in place 6 inches from the property line. During construction of the house, we made a good faith effort to correct the situation by relocating the shed further to what we consider the rear of the property, which is on the Beach Park Drive side. Both sides of our lot are treated as front yards. Moving the shed into full compliance with the 30-foot setback requirement on both street frontages would severely limit, if not eliminate, any reasonable location for the shed. The location was chosen to allow for reasonable use of the yard while maintaining access, drainage, and functionality of the property. This was not done with the intention of disregarding zoning regulations, but rather to a misunderstanding of the exact setback requirements. The shed is a small, low-profile structure. It does not impact sightlines, does not create traffic or safety concerns, and has not caused any drainage issues. It is consistent with typical residential accessory structures and does not negatively affect neighboring properties. Granting these variances will not substantially affect the comprehensive zoning plan. The garage encroachment is minimal and the shed is unobtrusive and appropriate for the property. We appreciate the board's time and consideration and respectfully request approval of these variances.
Thank you. Anyone on the committee have a question for that?
I do. Can you explain, did you have a surveyor layout? This was new construction?
Yes. There was an existing home that we
Tore down?
about double down to the
This one.
basement, yes, and then
Thank you.
we added on to the garage. And
Let's see.
Yeah, we kept the foundation and added to it. By adding to it, we were really close to property lines.
Now I gotta
Okay.
share.
It was oversight.
Did you have somebody
Somebody-
stake out the work when you were before the foundation for the garage was poured?
No.
Okay. Good.
I staked out to my knowledge, and somehow or another, I was off a foot and a half. And it's only a foot and a half on one corner, because the way the property line goes.
I see that. Regarding the shed, in the application, I keep seeing a reference to, a larger requirement for a setback, but I also see that based on the size of the shed, 5 feet is allowed.
That's correct. So we talked about this. So it's 5 feet. If it's under 200 square feet, it has to meet the full front setback, but it can be as close as 5 feet to the side and rear. So because they have 2 fronts, they have 2 fronts, 2 sides. So it would have to meet the fronts and then be 5 feet from the sides.
Did the shed have to be 30 feet
So,
from, as a setback?
so if it was over 200 square feet, it would have to meet the full setbacks for a structure. If
Yes.
it's a shed that's below 200 or 200 square feet or below, it can be as close as 5 feet to the side and rear, but they have 2 fronts because
Yes.
they have 2 streets. So instead of having front, rear, side, side, they have front, front, side, side. So they have to be the full setback for the fronts, and up the sides, they can be as close as 5 feet.
And that setback that she's referring to, what is that again? That's not nearly 30
It's
feet.
30 feet. 30 feet from the front. if you
Yes.
will, the
Both
front,
fronts.
And then 5 feet off the.
That's
side.
30 feet from the back as well, isn't it?
Because it's 2 fronts.
Yeah.
Mhm.
Is it?
Yeah, Beach Park and Shore Grove.
But the shed's not, because if the shed was moved to be on the side of the garage, which that whole side would be inaccessible. And the reason I put it over there was because it was out of the way also, but also it was protected from the neighbors' trees themselves. And it was the only place on the property that could go when we first, when we bought the house, the shed was literally 6 inches off the other person's property, and nothing was ever said about that, but it was just put there without trying to cause any problems. It's on gravel, there was water flow.
Yeah. Now you have it on 4 feet on one side. Why didn't you just make it on 5 feet?
I have no problems with it. It's another 5, moving another foot. That's not the.
Was it was just just a mistake?
It was totally, but, yeah,
Okay.
totally misunderstanding. I made a mistake on my end, yes.
So when
Like
you
to share.
purchased the house, this was never brought up
There was no surveys done, anything like that.
I haven't done this.
Not, I'm just asking for information.
Yeah.
In the right side, I'm looking at, you're on Short Road, on the right corner of the property, it looks like there's enough room to put the shed in that front corner and meet the 30 feet. Oh, is that right? Am I reading that right?
Yeah.
Right.
We have it up on the big screen.
Sorry.
Yeah, so on the property adjacent to Beatrice Burnham property, in that box,
Right.
says building setback line. Yeah,
Where
you're
the halfway
closer.
is?
Yeah, to the right front corner of that box.
Over here,
Yeah, that's 30 feet, right?
and that would be in the front yard if you wish, coming down the road. I think it'd be more of an eyesore than ours is not an eyesore where it is now. Putting it there, it's just it's don't think it's would be as aesthetically pleasing.
Love that question.
Is there anyone, who would like to speak in favor of the application?
I have a letter from a revenue report.
Okay.
They couldn't be perfect.
We should read that into the
You
record.
should read it or.
Yeah, and then we'll take it for the record too. We can add it to the application file. And do you want Tom to read it or?
Anybody can
All
read it into the
right,
record.
is it okay if I do? Okay, so this is a letter dated May 18th of 2026 to the Zoning Board of Appeals regarding ZBA 26-25 Shore Grove Road. Dear members of the Zoning Board of Appeals, I am the immediate neighbor and direct abutter to 5 Shore Grove Road. I am writing this letter in clear and strong support of the variance application submitted by Lori Seeger and David Seeger. I am aware of the existing house and shed location. The minor encroachments being reviewed by the board have no adverse effect whatsoever on my property. The shed is small, discreet, and consistent with normal residential use. The garage encroachment is minimal and has no impact on neighborhood appearance or property enjoyment. From my experience, living adjacent to this property, there have been no issues, disturbances, or negative impacts related to these structures. I believe the requested variances are reasonable and appropriate given the property layout and do not conflict with the character of the neighborhood. I fully support approval of this application. Sincerely, Richard and Rose Jones, 7 Shore Grove Road. So I'll add this to.
Is anyone in the audience here today in opposition to this application? Okay. Would anyone like to ask general questions about the application? Do you have any response to any of the questions you've been asked? Any other?
We still, I think we covered everything.
Okay,
I have one more question.
yes.
I'm just gonna keep asking for information.
Sure.
Going back to what you call the Beach Park roadside or rear, on the right side, there's still room in that corner for the shed, can still hit the 30 feet, keep going up. No, that back house.
Up
back
here?
house. Yeah, and that go forward into that section.
So there's
Yeah.
a dogwood here.
Yeah,
Um,
that little rectangle right
And
there.
this, so, oh, so I see what you're saying. So you'd go all the way up here.
I don't know how to describe it, north, south, east, west, whatever, so I'll just.
Front road.
This is your 30-foot setback from the rear. Can your shed fit in that area? And then the second question would be, what would be your hardship in terms of what's contained in the shed if you were to lose the shed?
Well, if we put it here, it'll be like in the middle of the backyard. And as we all know, the yards aren't that big as it is. But put it over here, there's gonna be a little seating area for a patio and then the shed in the middle of the yard. I'm still gonna go back to where this is more pleasing for the neighborhood also than over here.
Okay.
Yeah.
Thank you.
Do any other members have? Do any other members have any other questions? Okay. Does anyone in the public, wish to speak? What's that? No one wishes to speak further. I'd like to, ask for a motion to close the public hearing.
I'll make that motion.
Is there?
Need a second?
Yeah, is there a
I'll
second? to close?
I'll second.
We can either choose to vote.
Oh, you
All in
can vote on
favor?
closure, that you just add.
Oh, yeah, I'm sorry. So, yeah, all in favor of closing the hearing?
Hi.
Any vote? Anyone abstain? Okay, the hearing is closed. So we can either, how does that work about?
Yeah, I don't know if you want to
So
speak.
the commission could begin its deliberations on this matter. That would be one thing. I'm seeing on the agenda that that's these things are listed one time. So you could begin your deliberation on this and then provide staff with direction about where you'd like to go with this, and we can craft a motion for you for the next meeting.
If I may.
Yeah.
This is my first time with you, so I thought I would jump in again. For the record, Jennifer Coppola from Ciolo D'Onofrio, new counsel to the zoning board of appeals. Just on your day-to-day business. I know Attorney Buster is here for a litigation matter that his firm is handling. I just want to remind you before, because you do have number of variances tonight, just remind you about the requirements of your regulations. You have very specific requirements. And so if you will just bear with me on that, because we've never talked before. So I like to always sort of give a reminder about, what the requirements are for the granting of a variance. And your language sort of does more than what the statute does in terms of offering you guidance about the types of things that don't constitute a hardship. So I think it's important that be of record. So first off, your authority to vary the zoning regulations and your jurisdiction over variances comes from Connecticut General Statutes 8-6, Section 8-6, specifically A3. It says to determine and vary the application of the zoning bylaws, ordinances, or regulations in harmony with their general purpose and intent, and with due consideration for conserving the public health, safety, convenience, welfare, and property values. Okay, so stop there. That's one requirement. All right. Solely with respect to a parcel of land where, owing to conditions especially affecting such parcel, but not affecting generally the district in which it is situated. Another requirement, unique to the parcel. A literal enforcement of such bylaws, ordinances, or regulations would result in exceptional difficulty or unusual hardship. Another requirement, the hardship requirement. Application of the regulations would result in that exceptional difficulty or unusual hardship, so that substantial justice will be done and the public safety and welfare secured, provided that the zoning regulations may specify the extent to which such uses will not be permitted by variance in districts in which such uses are not otherwise allowed. So that's a separate issue. You don't have a use variance before you on this. Just in terms of your regulations, you're looking at section 13, specifically 13.2. And it, like I said, it's extensive because it not only does it recite in similar language the requirements, the statutory requirements, because remember your authority comes from the statute, so your regs can't do something other than what the statute allows your jurisdiction to be. But 13.2 says the following. Variances shall only be granted where such an action would be in harmony with the purposes of these regulations as set forth in section 1 of these regulations. Okay, so that harmony, again, that you see at the beginning of the statute that I just read to you, again, 8-6A3. And where literal enforcement of these regulations would result in unusual hardship. So unusual hardship is used, but we know that the law also encompasses term of exceptional difficulty as defined by the courts of the state of Connecticut, which may be summarized as follows. And again, there's real guidance in your regulatory language in terms of deciding these types of applications. 13.2.1 provides that the hardship recognized by the law is that of the property due to its unique shape, topography, or other inherent physical conditions. Okay, so that's what that uniqueness is. It's a land-based uniqueness. You have to make that determination. And A and B at 13.2.1 says the personal hardship of the owner, such as age or family condition, is not a legal hardship, which would support the granting of variance. B, the hardship must not be merely financial, such as the owner would make more money or lose less money if the variance were granted, as financial hardship is personal and not inherent in the property itself. Okay, so that could be a little bit confusing. What it's saying is that it can't be personal. Okay, it can't be merely financial. It has to be inherent in the property itself, again, that uniqueness, land-based hardship or difficulty. 13.2.2, the hardship must be, again, unique to the property in the same sense that it is a characteristic which is not exhibited by other properties in the area or in the zone, and which makes it appropriate for special treatment. Okay, so it has to be different. And A and B of that subsection, again, 13.2.2, A says merely being too small or too narrow is not a legal hardship unless it restricts the property from being put to a reasonable use permitted in the subject zone. And B says if the surrounding properties are predominantly too small or too narrow for current zoning standards, that is not a legal hardship and that it is not unique to the property for where the variance is being requested. 13.2.3, the hardship must not be created by the owner or his or her predecessor in title, such as dividing a parcel to create lots which cannot support the desired use, or creating a topographic condition by excavation, fill, or other measures which render the property unusable for its highest use without a variance, or by building a structure which, for whatever reasons, violates a current regulation. 13.2.4 speaks to the burden. Okay, so those are all the findings. The burden, 13.2.4, the burden is on the applicant to demonstrate that the requirements for a variance have been met. And then 13.2.5, variances are to be granted sparingly and only to the minimum extent necessary to allow property to be used for the least intensive use which is permitted in the subject zone. So that minimum, okay, that's considered another requirement of the law, that the request must be just enough to address the difficulty of the hardship. Okay, I'm sure you've probably heard this before, but again, it's a good idea to go through it. I don't know who in the public too has been here before, who's familiar with your regulations or not familiar with your regulations. It's helpful for the public to understand too what your authority is. Now, in terms of the vote itself, you do have 5 sitting. If you only had 4, we typically would give the applicant the option to not have the matter decided. But that is not an issue tonight. But that requirement comes from the requirement to have 4 that agree, that concur on the granting of variance, comes from section 8-7 of the general statutes. It says the concurring vote of 4 members of the zoning board of appeals shall be necessary to reverse any order requirement decision of the official charge with the enforcement of the zoning regulations. And I know you have an appeal application later, so that comes in. or to decide in favor of the applicant any matter upon which it is required to pass under any bylaw, ordinance, rule, or regulation, or to vary the application of the zoning bylaw, ordinance, rule, or regulation. So of course, we do need to agree. If you are going to, in fact, vary the zoning regulations. So, we do, I believe, have, access, you've seen all the supporting documentations with regard to this application. If there's anything as you deliberate that you would like staff to, I think it's great you have a screen, you'd like staff to put up, because I see that you don't all have tablets. Certainly do ask them, to do that. They can do that for you, okay? And you can consult with staff and council too. Of course, it's on us not to introduce anything that was not introduced in the public hearing, in terms of factual evidence or such, or it's not in the record. But you can consult with them, okay? Thank you so much. I appreciate the time to do that.
Thank you very much. So I believe the step is to see, each of one of you, are you ready to, vote? Have other questions? Go around. Would you be prepared to vote at this time?
Yes.
So just a point of order for the town attorney, so I normally staff would have motions prepared, but we don't have them this evening, and so is this something that we would craft on the fly, or is this something that we're recommending that the board deliberate, give staff direction?
Really, it is up to the board what you desire in that regard. I know that some boards do prefer to have a discussion and then to direct staff. I will say this to you, the law does require that you do state your reasons on the record, and specifically are, and this is further on in 8-7, but you need to make that hardship finding again if you are going to grant the variance. So you do have to or find that there is no hardship if you're going to deny it. That is an important piece that the court does look at. So it really is up to you procedurally what you prefer, what you feel most comfortable with. The other thing that is very important is that you need to state collective reasons, meaning it has to be the decision of the board, what the reasons are to support the action taken. It needs to be clear in the record that the reasons are the collective reasons of the board as an agency and not individual. So typically what I do recommend with regard to that, and I've tried a number of these, I've been practicing land use for 31 years. I tried a number of land use pieces, and this is an area that is sometimes a discussion where the agency's reasons are not necessarily clear in the record. I do recommend, if you are going to proceed to vote tonight, that whoever makes the motion to vote, that you state as part of your motion that you're proposing for, again, whether you're moving to approve, moving to deny, that you're making that motion based on the following proposed collective reasons of the board. And then if each board member could indicate that they agree with the collective reasons, you could also ask the movement to amend their motion. And the process for that is that the movement may choose to amend themselves. They may choose to withdraw and allow somebody else to make a motion. But if it is an amendment, you move the amendment to the motion as a separate motion, and then you make the motion in the main, and you vote on that. And if you have any questions about that, that is a Robert's rule that is oftentimes not followed. So you gotta be careful, because again, things are being recorded for a reason. And we've got to make sure we have clear. Okay. Any questions about that? Again, this is my first meeting, so I try to offer the guidance I think will be helpful. But I think we should have a discussion about what everybody is thinking about this application. And the direction.
What would determine whether we did not have a vote tonight and we put it in abeyance?
So that's entirely up to you. I will just offer you some guidance as far as your timelines are concerned. So 8.7D, General Statute 8.7D requires that when the application is received, you have 65 days to notice the public hearing. The public hearing, you have 35 days to hold the public hearing from when it starts to, rather 35 days to close it, forgive me. And then from the time that it's closed, you have 65 days to decide it. There is also an additional 65 days within the statute to extend any one of those periods, but that is done with the consent of the applicant. The applicant has to agree to that, to use that additional time. So 65, 35, 65. So you can't go obviously to the next meeting and probably do not.
Correct. You have essentially 2 meetings in which the statutory timeframes require you to act under the standard timeframe. So you could deliberate and we can help you craft a motion this evening, or you could deliberate and direct us to come back to you with something sort of written up for your consideration at the next meeting.
We just kind of need to know what your thoughts are and reasons, so we know if you do ask us to help you craft a motion, how you want to read or which direction you're going.
What would be the mechanism by which we would meet if we didn't have a vote tonight?
Oh, you have to do it here.
It would be at your next meeting.
Yeah.
Sorry?
At your next meeting.
Or we would have a vote at the next meeting.
Correct. You could take a vote tonight, or you could take a vote at the next meeting, but anything you do happens during your meetings.
So
Yeah.
my perspective would be to grant the motion, the variance on the garage as strict adherence to the regulations would be an unusual hardship with the fact that there are 2 front streets and there are a few homes, although there are several in that little community that are similar in nature in terms of the hardship of 2 front roads. A variance of 18 inches, these things happen in building. But I would be more reluctant to approve the shed. Even though it's a small shed, the fact that, it's 5 feet would work, but because of the 2 front yards, is it really literally 2 front yards? It's not a front and rear setback? It's
So
actually
when you-
zoning called the 2 front yards?
When you have, well, it fronts on 2 streets.
I understand that,
So-
but isn't it still referred to as a front and rear setback?
No, because you have 2 fronts. Normally, if you had like a house on, say, on East Main Street, this would be the front, the rear, and the 2 sides. When you have 2 streets, you have 2 frontages. So it's front, side,
Yeah.
side.
So the way the zoning regulations defines it is where your front setback is measured from where that line abuts to the street. And so that's the
And not the street address that your house is attributed to.
correct.
Okay. So I would like to hear other people's perspective on my thoughts.
Well, I'm inclined to allow a variance on the shed. I appreciate the fact that the shed is in a location in the rear. There isn't room back there for 30 feet unless we move that more to the front. And he has taken into account the aesthetics of his property, the concerns that the neighborhood might have, and the impracticality, frankly, of putting the shed more in the front yard. I visited the property today. It's in the back. It's where a homeowner would normally want his shed. He does not have enough room for that 30 feet. So I would grant a variance on the shed.
About the garage.
The garage, I have no opinion on it, frankly. I have no opinion. Somehow that escaped me. On what we're talking about.
Yeah, well, the garage That's outside the allowable envelope. This rectangle, this dotted line here represents the allowable building area that meets the setbacks. That's what this dotted line
Okay,
represents.
where's
Here's the garage. Here's the
Okay.
garage. This lower corner is 18
Where's
inches.
where's the north on this?
Do you want to come over, Joe, so you can see it a little closer?
No, I think I can see it. Just tell me where the north is.
So the north
Look-
arrow,
Is that the front of the house? The front of the house is east, isn't it?
yeah, so here's
Is
your
that
north
right?
arrow right here.
Okay. Front of the house is east.
This is Beach Park, Shore Grove.
Okay,
Does that help? I know in the way.
yeah,
Yeah, so this little area here
yeah,
is the foundation of the garage.
okay. What's the issue again with the garage?
It's outside the boundary of buildable space by 18 inches in that one corner.
It encroaches into the required setback by 18 inches.
Well, I would do allow variance on that. What else can you do with the garage?
Well, I think you were looking for reasons that, you
Yeah.
know, as
The
Attorney
garage is there.
Capola mentioned,
The garage is there.
right, but
Is
they're requesting an after the fact variance.
Yes.
So I guess the question is, what would be in your hardship? What would you consider to be a reason to grant that variance? If you were to find collective findings?
how can he just knock that down or the whole garage?
Well, what I proposed was the hardship is the uniqueness of having two frontages
Yeah,
and the requirement of having 30 feet on both frontages.
yeah,
And the fact that the correction would be costly and the infringement is not overwhelmingly negative or harmful to the population, doesn't create a hazard. Am I saying?
You're giving reasons. That's what we need. Yeah.
I'm with her on this. I
My,
agree with that.
my one question on the way Beach Park Road is, how it's kind of cockeyed. If it was a straight road like Short Grove, would that have changed any of what we're talking about tonight?
Well,
With the way,
the whole area has the two frontages, the whole
I'm
neighborhood.
just looking at how it's kind of tilted a little bit, and on the other, it's more of a 90 degree. If they were both 90 degrees, would that have?
But I mean, and a lot of roads are curved.
It may have given them on this particular lot a little bit more space, but there are others that have a similar slant.
Yeah. The whole area.
That area,
Bruce, you have anything you want to ask or contribute?
I'm kind of in agreement with the group, in regards to, yeah, we're talking 18 inches that is, that exists today. And, to correct the 18 inches, to me, that would be a hardship in the sense that, there's a cost involved for that. The neighborhood letter, had some, weight with me as far as, it's not obstructing anybody else's, nobody else is upset with the change. Nobody else is having an issue, with the variance. So, I'd be inclined to go, to move forward with it.
But there's two variances being requested, so that what we're sounding like we're agreeing on is the garage issue. The shed is a separate variance, and the problem is because of the two fronts. Do we want to allow the 5 feet for the shed, or do we want the shed removed?
The shed was there originally, correct?
Was 6 inches?
6 inches.
you try to correct it.
Well,
The public
we
hearing is
can't interact with the public once the public hearing is closed.
Yeah,
sorry.
closed.
Stop breaking all sorts of rules.
He moved it 4 feet.
It's supposed to be 5.
It's actually supposed to be 30 feet from the
From the fronts and the sides is 5.
side. Is fine.
So, I guess we're everyone on thoughts.
So do you have a
No one's
consensus?
really talked about the shed. Other
I talked.
one to do it. But there needs to be one of the reasons that was described to us in section 13.
So just to jump in on that, let me be very clear about something, because this is a common confusion. You have to make all those findings, okay? It's not just a hardship and exceptional difficulty situation. It is harmony too. It is just the minimum necessary being asked for. So it's a land-based hardship that's unique to this property. All 4 of those things are findings that you need to make. And that's something that I will say is a source of confusion for a lot of zoning boards of appeal, is that they think because so much of the focus is on the hardship issue, they focus on that and they sometimes don't consider the other things. But it's all of those things. And just be careful too, because I've heard some comments about financial. That is something, and your regs do offer very specific guidance about that. The case law, the interpretation is that financial considerations do not come into play. That is not the type of unusual hardship, exceptional difficulty that the law recognizes as a legally cognizable hardship. So you've got to be careful about that, and it is in your regs. So people are ordered sometimes by the court to deconstruct, on further appeal. So it does happen, and it's listed as an after the fact request. We don't really take that into consideration. Okay, the fact that it's after the fact shouldn't really be taken in. You're still doing the same analysis. This should be analyzed in the same way as if they came to you before they constructed anything, because that's what a fair hearing on this constitutes. Is not, because oftentimes after the fact does hurt the applicant, although I'm certainly not hearing that you would be inclined to do that, and I would be warning against that if you were. But you're still doing the same analysis as if they came and they said in the first instance, before they built anything, could we do this? Would you consider it to be something that's acceptable to vary your regulations for? So just be careful on that.
I'm not sure, next steps.
So I think what I would recommend to the board would be to sort of, you can do one of 2 things. You can continue deliberations and continue to consider the hardships Attorney Capola has presented them to you tonight, and think about them and come ready to discuss them at the next meeting. You can also direct staff to prepare you motions to be ready with, to help you have something to sort of put some framework around this, and to make sure that when you make collective findings, that they are carrying all of the points that are required by law for you. So if you think that you are going in a particular direction, you can certainly say, staff, we'd like you to craft a motion that leans in this way for us to continue deliberating in the next meeting. But it sounds as if some additional support on the language of this motion is probably necessary.
I would agree with the latter. To draft the motions for the next meeting.
Yeah.
Is that? Did I paraphrase you okay?
Yeah, I think I would be talking that way too, especially you raise the point of, so you're saying that we're talking about 2 variants. Is that not really accurate?
No, there's 2 different ones. One is for the shed,
Yeah, well,
Once we
okay,
garage.
just to be clear, that, yeah.
And you can book separately.
Okay,
And
That's
really
my
ultimately should, right, because the analysis is a different factor, analysis for each. Given, you know, the nature of it, the circumstances, and certainly, of course, the underlying requirements, right? For each.
just in my view, well, I'd like to move it to next meeting so we can consider it. Because the point being is that they didn't really do what they should have done, and that's why I'm here, is that, you know, really,
The point being, whether it's on the property or not on the property yet, the point being, you know, does this strictly conform to the zoning regulations, and have they met the requirements of hardship in order for you to grant variances?
so the next step should be have a motion to whether we want to move it to the next meeting.
Correct. You would have a motion to continue to the June 17th meeting.
Someone would.
I'd like to make a motion to continue the decision-making to the June 17th meeting based on, to be accompanied with suggested motions by the staff.
Great.
second
Like the second thing. So, all in favor?
I got on the order.
Yes.
I don't understand what you just said about the staff.
Staff being Abby or Kathy are gonna prepare motions with some language to allow us to discuss more of the legal ramifications of our decision with some guidance.
So basically, we would craft you something that you could consider, and you could make changes to it. You don't have to accept it the way that we write it, but based on what you've heard tonight, we would give you some language to continue your deliberation, so that you would have something to kind of react to and be able to say, okay, we agree with this, we believe this is correct, or we want to tweak these things, so that you'll have a chance to consider something in front of you.
Is it usually done?
Yes.
All in favor of this motion? Any opposed? Any abstain?
I'll go get Lori.
Thank you so much. We'll see you next month.
I want to state on the record that I am resuming chairmanship meeting, and I assume it was John who served as a member in my place, and I am unseating you and resuming my seat as a member. Thank you.
Okay.
ID ZBA 26-3, 82 High Street, Assessors Map 44 / block 26 / lot 11 R20 zone. Joe Wren applicant. Gary Gio owner. After the fact request for variance for ground coverage to section 26.11.14. Again, if the public hearing and eligible for decision is public hearing is closed. In a moment, I'm going to go over the steps that we'll be taking, but I would like to direct a question to our town attorneys. If I was not present during the hearing on this previous case, which also was a, it states it's an after the fact variance, and this, matter now is an after the fact variance. And I'm just wondering, town attorney, if there's any information in terms of the procedure, how the discussion went, that would be helpful for me to know in terms of, leading the board in the.
So, what I did, Madam Chair, was I did review, the statutory language, state six, which provides the authority to the board to act on, variance applications, and then I did review by going through, each specific requirement contained in 13.2 of the regulations for the granting of variances, and also what I consider to be some instructional language that you have in your regulations themselves in terms of the type of hardship that's appropriate. And so we did have some discussion too in the deliberation of the last application with regard to some of the requirements and the guidance that is in section 13-2 or 13.2 of your regulations. And in terms of, again, these two applications being after the fact applications, certainly, of course, we want people to come in. There's a lot of circumstances under which you do receive those types of applications. Sometimes folks are not aware of the requirements. Sometimes errors are made. Sometimes things do change during the course of construction as well. So I did give the advice, the guidance that, the fact that something is quote unquote after the fact should not hurt and should not result either necessarily in any favor of the application either. I do point that out. It kind of does run both ways. I think obviously the analysis should be the same because you have to make the same findings. The law requires you to consider the same requirements regardless of the timing of an application. So, exercise your authority to vary, there are requirements that must be met by law. So, I think you can proceed unless you have any other questions. And
Thank you. Generally, this might be similar to what Tom Phillips may have said with respect to the previous application, but we will ask the applicant to present his case. The board can ask questions then, give comments. I'll ask for any staff comments, and then we will hear from any members of the public who wish to speak either in favor of, in opposition to, or have general questions about the application. And then I will ask if the applicant wishes to respond to any of the comments or add any additional information. And we will ask again if anyone in the public wishes to speak. And then we will decide if the board has enough information to close the public hearing tonight. The board doesn't have to do that. It can be continued, and then we'll take it from there. So is a representative of the applicant here tonight.
Yes, Madam Chairwoman. My name is Joe Wren. I'm a professional engineer of Indigo and Old Saybrook. With me is Chris Tennis. Chris Tennis is from Gilead Community Services. He will talk in a moment just to give you a little background. Why we're here today. Is it possible to blow that up a little bit?
Sure.
The only reason why we're here tonight is there was no previous Board of Appeals application. This was a site plan that was prepared and submitted to the local health district and town staff because it met all the zoning requirements at the time it was proposed. So, very brief history. This yellow shaded area here was a 3-family house that burned out. Owned by Gilead Community Services. They're a 501c3 nonprofit. They help our community members falling on difficult times and some that need accessibility requirements as well. So unfortunately, that structure that was there before burned down. So with this application, what they wanted to do is to rebuild that, three-family, that was there, three-family, multifamily dwelling that was there before, rebuild it, but of course, in accordance with all today's 2025 and 2026 fire codes, safety codes, accessibility requirements, and so forth. As you can see, the dwelling was very close to the northern property line, just within a few feet. And with this, we were able to work with staff, and we were able to bring it into conformity. So the dashed lines here are the setbacks, 25-foot side yard setbacks, rear yard setback, and the front yard setback. So you can see that the structure fit inside there and it worked. All of the other zoning dimensional requirements were all met with this. So this was submitted to town staff, it was approved, and so forth. We also replaced the septic system in the back. So there was an antiquated septic system there, and they elected to, even though they weren't necessarily required to, but they elected to entirely replace the system with a new geometric system with a properly sized tank. That is all on the ground. The house is all built. The house is moved in, and so forth. So everything is done and up to snuff with all permits and so forth. This is also on a state road. So Connecticut Route 81 is here. We had to work with the DOT. The sight line coming out of the driveway, looking to the south or to the right, was very challenging. There was a steep hill there. There was a lot of brush on that hill. The DOT asked us to improve that sight line, which was done and all fully approved by the DOT as well. So this is a safer intersection now as a result of this project. They would have had they didn't have to do any of this if the house didn't burn down. They could have kept the existing condition and continued to operate. But as a result of this project, it became a much safer, conforming, code conforming project all the way through. The other thing that was done before I just let Chris speak for a minute or two, just so you understand what Gilead does and their benefits to the community. The other thing I wanted to mention is the former building was not handicap accessible. There was no handicap accessible parking. An accessible needs person couldn't get into the building or out of the building. This provides two accessible requirements of parking. So two of the three that are here now is handicap accessible. Meet all those current codes and building requirements. So we feel overall that the project is much better. It's safer. It's more consistent with your zoning regulations, more consistent with plan conservation development of town and so forth. So the reason why we're here, before I bring Chris up again, is that the driveway originally, when we submitted the site plan, the driveway from the DOT line up to the building, with the exception of the handicap parking spaces, which are required to be paved by code, all of the yellow area with the orange outline, that was the proposed driveway previously, and all of that was to be a crushed stone, so a permeable surface. With the exception of the DOT paved apron and the handicap accessible area. And that allowed us to stay below the 15% coverage that's required in the zone. Last fall, without knowing, of course, at all, before the asphalt plants were closing down for the year, Gilead just made an individual separate decision for the safety and accessibility of their clients of having a solid surface here. They paved the driveway in the park. What that did is we got the as-built. We were preparing the as-built with the surveyor, and the as-built survey came back and it showed a paved driveway. So then we look at all the zoning dimensional requirements. We meet everything. The house was built in the right location. This is the as-built map, by the way, but the driveway was paved instead of crushed stone. And in Clinton, not many other towns, driveways and residential zones count as coverage. So this brought us above the 15% maximum coverage, the 21.2% coverage with the land area that they have. So that is the main crux of the application, the main purpose why we're here in front of you. And without further ado, I'll let Chris just tell you a little bit about Gilead, and then I'll wrap up and ask for any.
Gilead is a nonprofit operating out of Middletown, and we serve people who fall on hard times with, are licensed by DPH and DMIS for mental health issues. So the purpose of Gilead is to be the support net to keep people from becoming homeless. So what we do is we provide housing such as this and support services. And the goal is that this is not a permanent location for the people we serve. They get back on their feet, get into another apartment. They have outpatient services with us till they're back without need of us. And that's the safety net that's been in operation since 1968. And we're actually part of Oak Hill, which has been in operation since 1893, which was a school for the blind, where we cover kind of all the bases in the people we serve. So really, the fact that in the state that we paid more than we should have is in essence for the public, the people we serve, to be able to get in and out. Normally, we don't serve a lot of people with multiple disabilities that aren't ambulatory, but oftentimes we have people, they come in and then they have a problem, and then they're in a house. The previous house had outside stairs, no access at all. So out of the 10 locations we have at Gilead, this would be the second accessible space. So it really is a needed thing for people we serve. And you know what it's like if you're in a walker trying to go across the gravel surface, it's not good. But anyway, we didn't intend to do it that way, but that's the way it came out and why we're here. Any questions?
How many people are resident in this location?
This location, it has 3 bedrooms, 3 bedrooms and one 2-bed. So we use the bedrooms as an individual unit as a place. So it's like a common kitchen. But if there is a family, well, then they get more than 1 bedroom. Depends the people who come in and how we move that around.
So that can vary.
That varies, yeah, depending. So, because sometimes we get families, it's just how we get our clients and who comes to us. Do our best to take it. And especially here in the shoreline, there's very good affordable apartments. Any other thing?
Did you have access to the site plan and the specifications that it was supposed to be gravel?
Yes.
And when the asphalt company came, did they understand that it wasn't supposed to be paved entirely?
No.
And was the fault with the asphalt company?
Well, there's both, actually. The asphalt company, the general contractor, and Gilead itself. It's kind of fell through the cracks with 3 sets of eyes.
But just to clarify, Joe, run for the record, just to clarify, it was really not at fault. Most lay people that don't do this for a living or sit on these boards don't understand that asphalt in a residential setting or residential zone counts as coverage, counts as building coverage or lot coverage for that. And in many towns we work in, they exempt residential driveways from coverage requirement for various reasons, or they have a larger coverage requirement. Like Westbrook, for example, has a 25% coverage requirement. See, there's on this is a 15% coverage requirement. So, but whether it's the paving company was just okay, yeah, we see your new site, we see the stone area, we want to pave this, spray paint outline, I think we're good. Really looking at the site plan and seeing what was required on the site plan. Gilead ordered the paving, right?
Mm-hmm.
They just, the asphalt plants were going and they got the estimate and they just hadn't paved, followed that direction. But Gilead did not know because they don't understand this part of it. Yes, they have the site plan. They just didn't understand that by paving it, they were going to even go over coverage.
When did you get involved?
I was involved right from the beginning to do the site plan, get that But then we don't track it, we don't say, oh, or you have to driveway paved. Hey, we get the plans approved and we give them to the client hires their contractors.
Was it 15% with the crushed stone?
It was under 15% with crushed stone, yeah.
So then, okay.
This yellow area with the
Yeah.
turnaround and the orange highlight, that's what was originally proposed. All the way through, and then the as-built, it has this purple outline, so that's what's there today. So it generally followed the same shape. They didn't do this.
Yeah.
The difference being is that only this was supposed to be paved, and now this is all the way through. Now, the other thing I wanted to point out that I didn't mention before is the third piece that we show on here. This part of the driveway is very narrow. You can see really couldn't get 2 cars by there, and there was a big hump. So that was improved too, but the driveway was paved up to approximately that point previously. And then from there all the way up to the building, there wasn't really any striped parking spaces. It was just kind of an open processed stone area. So all of this area that widened out here was a processed stone. And if any of you know what processed stone is, it's just a really compact broken stone or crushed stone that is not a decorative stone. It has fines in it, and it gets really compact over time. And it gets potholes, and the water sits in that and so forth. So that's what this was. There was some broken asphalt too. So we didn't really account for that because it was a stone parking area. We did account for that in the existing condition, but it still was not over 50% before. And now with paving that yellow portion with a purple outline in the dots there, that put them over.
So the original driveway was crushed stone?
It was paved up to here.
Okay.
With that red outline was paved up to that point from the road. And then here was the processed stone. We didn't have a record because the house had to be demoed after the fire and so forth. So between there and where the house was before, we didn't really have that well defined because it was all disturbed with the demolition of the house. But this red outline, this was processed stone, compacted processed stone, and then this was paved.
So how many years has this driveway been there?
Long time. I mean, how many years has Billy owned it? The house was old.
The house was,
So the decision to pave the driveway was based on what?
accessibility and asphalt plants closing. It was like, we were trying to get a CO, get moved in with people and opted to pave it.
So this has been a problem for years, correct? The accessibility issue?
The accessibility issue has been a problem for years. Before the house burnt down, you didn't have any accessibility. The new house was finished in December, so that's when the paving went in, was in December of 25.
Okay.
The former house was not accessible at all. Now it's accessible. Now two of the units are fully approved accessible units. So folks in canes, wheelchairs, walkers, or whatever can be let out of the van or something on this parking area and go up the ramp into the house. So a solid surface is better. When Gilead looks at this, what could make this, idealistic for our future clientele? When I say clientele, again, they're not for profit at all. It's a non-profit 501c3. But what is better? What's easier for? Doesn't matter the age of the person, but if they have issues with balance or walking, is it easier on an unstable roof surface?
So it's a problem you've been dealing with for quite a while, correct?
Yes.
Yes, but it wasn't accessible before. So now that it's accessible, it's more of a concern.
Was the decision to have it in gravel rather than paved because you wanted to make sure that you were conforming to the setbacks?
We wanted to, no setbacks, there are no setback issues here. But the coverage, yes, we wanted to be below the 15% coverage and for stormwater runoff.
And just to be, just to be clear then, I mean, there was just supposed to be a small area of handball where people, walkers and so forth, as you mentioned that people don't do well on crushed stone.
Yeah, I observed one day when I was there that accessible vans enter the site and leave the site, and they'll lots of times they'll either park anywhere that's available, or they'll just pull into the open area, and then they'll set the ramp down, and then they'll let them out to the parking area.
How much asphalt was poured, or how do you measure it in terms of area? How much?
There is, if you scroll up a little bit, someone scroll up. So on the zoning table, you can see we quantify the 15%. So that 15% of the lot area comes to 5,721 square feet. The 21.2 that's there today after paving is 8,075 square feet. So there's about 2,300 square feet extra.
Which of course you pay for.
How much vehicle traffic is there in this? Like daily, you get 3 vans or 10 cars, or just a rough number?
Daily, you'd probably have a good 10 cars.
And I saw that you would be willing to put in rainwater mitigation.
Yes, that's part of this. So if the town has a process that if you are over your impervious coverage from your existing condition, which we are, that portion of the overage has to be retained on site and treated for stormwater. So if this were to be approved, we would develop a stormwater plan, work with Billy to develop a stormwater plan, submit it to the town, and the town would submit it to your consultant. And consulting engineer to review the drainage.
What provision is that? Refer to provision?
I don't know the number, but
so there's various
Yeah, sure.
pieces under section 10 that refer to drainage requirements. There's also under our nuisance sections a requirement not to let water go off. There's also the MS4 requirements, municipal separate storm sewer. So no one is actually allowed to direct more water off of a site. So
yes, and that's common all across all sites, all towns. It's if we had 25% coverage here before we went down to 21.2%, then we wouldn't have to do it because we have less coverage, less runoff. But here, since we have more runoff than we had for the existing condition, we create more surface runoff, so we would retain that on site, treat that.
Has that plan been done yet?
No, because it depends on your review. If again, as it says in there, and what we had discussed with town staff is that we would go to the Zoning Board of Appeals first if we were fortunate enough to get a majority vote positive on this application. Then we would immediately do the stormwater and submit it to the town engineer. Prior to, is there placebo in there yet? Placebo?
No,
Okay.
it's temporary.
So they have a temporary C of O to occupy and have residents in there. So this would be prior to them getting a full C of O. It would be required to be reviewed and approved by your engineer prior to the C.
What is the hardship that's the basis for the applicant's request for variance? I didn't see any
So-
discussion in the papers about what the hardship is, which is required.
Hardship itself is not required. You could have reductions of nonconformity and improvements to safety, enhancements to safety as part of that. We have a two-pronged statute, and you could either have one or the other or both. We do lots and lots of these ZBA applications. We hear a lot of attorneys talk about this, and so in this particular case, similar to most after the fact applications, even though they're to be treated the same, that's absolutely true. They gave this without knowing. It's beautiful, it's good, it's in good condition, it's safe right now. And the only thing that would have to be mitigated is the stormwater, which obviously they've offered to do if this were to be approved. So we feel that it enhances the usability, the accessibility, and the safety of the property, plus everything that I mentioned earlier about reductions or actually eliminations. Could we scroll back up again? Reduction or the elimination of this, more than half of that building, you can see, or approximately half of the former building was violating the setback. There was a lot of bulk in that setback. Now there's zero bulk in the setback. Now, yes, that wasn't part of the original plan, but that's the result. They could have essentially, tried to come back and build a similar building in that similar area because they were kind of grandfathered in that area. But they chose not to do that. They chose to make it conforming. And all of those other points that I listed before about making it more accessible, safety, sightline, new septic system for health code, the drainage system that will be installed will enhance the property as well. And just to better service their clients. We think all of those things together, overall, looking at this overall makes a much better site, much more consistent with your zoning regulations and your plan of conservation development. And most importantly, safer site for these residents. So that's what we base our purpose.
But it's your position that you don't have to show a hardship as defined in section 13 of the code of the regulation?
As long as you could show reductions of nonconformity, enhancements to safety, and harmony with the purpose and intent of your zoning regulations and your plan of conservation development, yes.
Anyone else have any questions?
I have something. Did I infer that you have spoken to people in zoning about this?
We have,
And
leading up to this.
Like that he reached some agreement with you about, has he?
So there's no agreement as to what the plan includes. What we said was they have a path to come forward and apply. And the applicant, Gilead, because of the nature of their organization, they wanted to not expend significant funds on the engineering design for a stormwater system should the variance not be approved. I think it's important to maybe draw a little bit of a distinction between you're not bargaining for a variance based on compliance with other regulations, right? This is the stormwater regulations are in place and are required. If the variance holds, they have to put that system in. That is a regulatory necessity. So the question for the board is, even independently of that issue, would you grant this variance? Period. Correct. That is so yes, there was absolutely a discussion that said, if you come forward, you need to be aware that this is something that would absolutely be necessary. You cannot create another piece, but it's not a bargaining chip in order to get the variance. I think there's a distinction that has to be made there.
Is Clinton requiring driveways to be impervious as a?
So our zoning requirements, depending on the zone, they're for all the lot requirements. So setbacks, ground coverage. So impervious ground coverage is anything water cannot filter through. So it includes your structures, paved driveways, concrete walkways, Bilco doors, all of those things. They all are into the number for. We divide the square footage of ground coverage or impervious surface by the square footage of the lot, and that's where the percentage comes from.
Most towns are similar to that, but some do have exemptions for residential uses.
Yeah, but
like exempt residential driveways. That's just a distinction.
But Clinton includes all of it. Yeah, it's impervious surface. Water can't filter through. So.
I've got another question in regards to, it sounds like you've done some nice things. You've added a lot of nice features. I think for the most part, you've followed all the steps necessary to do everything. I'm just a little puzzled as to why all of a sudden in December, we're in this panic mode of trying to get this driveway paved before the plant's closed. And it sounds to me like you had said that it was sort of, you're kind of pointing the finger at each other, that, it was, mistakes were made. We're trying to get this project finished. You're kind of pleading ignorance to the fact that you weren't aware that this had to be done. Everything else was followed, but all of a sudden, why did the driveway have to go in December? Why couldn't we wait till spring?
Well, yeah, the asphalt plants closed down, and then you have plowing, and we had a lot of that this year as well. And you have, gravel loose surface plowing is different.
But you've always had a loose surface there.
Well, not necessarily. This is what I explained before. We had pavement up to here on a narrow driveway, And then we had a really hard compact processed stone surface, probably driven on a processed stone surface before. It's usually what they use below the asphalt for a good hard base under asphalt or under a road, but it really, because of that, it really packs down when you drive on. It usually creates an uneven surface with potholes and so forth. So that's what they had before. They had, generally a hard surface that was generally, there's a gray area in the regulations that says whatever surface doesn't allow water to drain through. One could argue that. And
So you could plow on this surface.
You could plow, but you rip up chunks of it, you get potholes, and so forth. So it's just an uneven surface.
Understood, but you had that every winter though, correct?
They
You plowed that driveway every winter.
In the past, at the old house, yes. So now we have a brand new house, $1.5 million. Really didn't want all that driveway tracking in the house by people who might not like the people. That was part of the decision to go and take it.
So
Sounds like a smart decision.
Well,
yeah.
maybe yeah, but not now.
The ignorance part of it, no one did anything with, Gillies profiting from this, they're not gaining from this or anything. They actually spent a lot of money. Not that it matters to this, and I'm just hating it. So it wasn't an easy decision. But again, like I said, the normal layperson doesn't understand that pavement counts as coverage and it's a zone. Most people think, hey, I have a crushed stone driveway, I want to pave my driveway. Well, in Clinton, you have to access the zoning regulations before you can do that. Oftentimes with other ZBA applications, we come in and we remove some of the applicants or our clients' driveways in order to create coverage for a building. So in Clinton, we always have to be sensitive to that. And in here, again, we had that area as crushed stone and this area paved should be under that 15%. We were out of it at that time. The building was already up. They just made the decision, executive decision to pave it without honestly knowing at all that there was any zoning repercussions for it. And we didn't know until we got the as-built survey and it showed all this blue outline here is asphalt. Said, okay, let's compute this, and it was over the 15%. And that's when we talked to town staff and said, we have the situation, here's the as-built, we have the situation, what are our options, and what's the best track that we.
So if the variance were to be granted, and if there was a condition in the variance, and then you go and have the driveway and have it planned and designed, and there's a problem with that, then what would be your next step?
If there's a problem with
the design of the stormwater, of a stormwater management system that wasn't deemed acceptable by the town engineer.
We feel that we have plenty of room on the property we do lots of sites like this. We feel that we have plenty of room on the property, that there's more than, again, this was all coverage before we had pavement. So we have to take those impervious areas compared to what we have now, and then we have to provide drainage for the difference. So we show an area here that's possible stormwater basin, but we'll have along this area, there most likely would be some sort of a water quality swale as well that will also retain volume. We're extremely confident, we do this all the time as civil engineers for water quality volume, that we can get something to work. And if the board wanted some assurance of that, I think we would be okay by saying if we can't get the entire driveway to work, then we'll cut back the areas that we need in order to get the drainage to work. Like say if we have 23 extra 100 square feet, right? Say if we could only get 1,800 square feet work drainage. I know that we can get all of it to work, but just to provide the assurance, if we only could get 18, then we'll cut back because we have to 500 square feet, and maybe that could be done along the width of the driveway, and try to leave this area where there's pickup and drop off as a smooth surface as much as we can. But I'm very confident as a licensed engineer in Connecticut that we can get the stormwater to work if the variance works.
I have a question about if you had specified that it was going to be gravel, but then the asphalt company put in all this asphalt. Are they charging you I mean, is it more expensive or is it relatively the same cost?
Much more expensive for
Right,
that.
I mean, I assume that, so you're getting a bigger bill because they didn't do it right, is that fair to say, or?
They were just asked to, hey, give us an estimate on paving. You see this area, that's stone, give us an estimate on
Yeah,
paving.
right now, yes, we're gonna end up with a bigger bill.
Yeah, that's his question.
And the other thing to consider too is if, even though we, can't talk about financial, but just a logistical thing, that if that asphalt was removed today, what's underneath that asphalt is that processed stone that we talked before. And it would just be an enormous project now that everything's stable and the grass is there and it's paved. It's been an enormous project because they probably would not want that processed stone there because of the reasons I mentioned before with non-pervious surface and potholes and so forth. If they had to remove all of that and put a crushed stone back in, it's even additional work, additional disturbance, and additional cost, even though, again, can't use that with disturbance through the whole area that's already stabilized. So it causes a lot of fun.
If you had realized what needed to be done in the beginning, in other words, it came to your attention that you're exceeding your limit, what would you have designed for the driveway? Where would you have eliminated the asphalt so that your coverage would be correct?
Well, we're about 2,300 square feet over. So we looked at various options before Gilead chose this option to request a variance. In cutting all this back, looking at thinner driveways, shrinking down this area, but it was too considerable. And you would have, like 2-foot sections along the driveway that would always be rutted. And
Well, I'm kind of what I'm getting at is, this is in the original design phase that, what are we gonna do to meet these requirements? It's not sort of, what do I need to cut out today? It's what would you have done originally to meet the requirements necessary?
Well, again, originally, what was originally planned is this orange, yellow shaded outline all the way around. So we had the paved apron for the DOT, which we had to make a certain width for sightline and to appease the DOT. You could see the old one was more narrow.
But that's not your responsibility.
No, it's not. But I'm just saying that we had to pave. That's off the property. It's not part of our coverage. But just starting there, we made that a little wider to appease DOT. But then matching from there, we were coming all the way back, and all of this was crushed stone, with the exception of the handicap parking area in that orange square. Everything was crushed stone. We were below. I don't remember the exact percentage on the proposed site plan. But it was definitely less than 15%. And then required
14.1 or
Um, I recall on some of my trainings that if an application, and we've seen some where they've reduced their non-compliance significantly. If it had been in an ideal world and not treating it as an after the fact, they would have applied for this variance when they applied for the building, the site plan would have included. Had that been done, we probably would have said there is substantial reduction in non-compliance and the fact that the house is no longer right on the boundary. And so we might have considered this as a positive application for a variance because of the improvement in the setback.
I think it's the apples to apples comparison. So let's say that they needed a 1 foot, variance for setback, and it was an overall reduction in the nonconformity for setbacks. That would be something that would be taken into consideration. But what we're talking about is different standards in the regulations. So yes, absolutely, the building is more conforming than it was before, no question, and that's wonderful. But applying that test to the driveway is challenging because it's not the same zoning regulation as you go down to the list. It's not the same category. And so that is not a reduction in the nonconformity.
Yeah, if they had a setback, say that they needed 7 feet, but it used to be at 4 feet, it's an improvement in the setback and it's reducing that. but this is a new nonconformity.
And I agree and disagree slightly just because it's eliminating an entire existing non-conformity. It's eliminating the setback non-conforming. All that volume, all that coverage that's in the north setback is now gone, and it conforms to your regulations. All the dimensional requirements and setbacks, everything you need to cut this coverage that we're talking about. And for the building itself and the pieces attached to the building, all that meets your coverage. It's just the pavement that puts it over. But you're eliminating a nonconformity completely, taking several thousand cubic feet of non-conforming building out of the setback. But then what Abby and Kathy are saying is that we've introduced a new non-conformity. So we were not over coverage before, and now we're over on coverage. So we're introducing a new one, but we've eliminated an old one. So to me, it's one for one. It's a good balance. Plus, adding in the enhancements to the safety of the residents and the site itself and the sight lines traveling the public and all that. I think that prompts everything.
That goes back to my legal question about what is the hardship is the basis, because I don't view this as you were saying, is an example of, you're a half foot over. We have had applications where there's, it's gone from many, many feet over, and then it's a real reduction. But again, every application is viewed, on its own merit.
Right.
On its own merit. Do the existing conditions, as it is now, adversely affect the use of the property or any of the adjacent properties? What are the properties next to this property?
If we can scroll up again, so they're residential use properties, and there have been no complaints.
No.
There probably have, I don't
They're
know if
very
anybody
happy.
has come over, so
Yeah.
they're very happy. Again, this building was that close to the property line before, so if I'm living here, that makes me happier. Now it's conforming, it's further away. For its tenants, just mentioning that there have been no complaints, there's been positive
Positive
feedback
feedback.
from both neighbors. 66 and 84.
Richard, definitely. I've talked to him on a number of times, yes.
From 84 High Street.
Right, I haven't talked to Stephen.
So we have a new septic system, so we're compliant with the health code. We have a DOT approved driveway, so we're approved with safety out there. So in general, and hearing what the neighbor said, no negative comments from the neighbor. In general, safer for the public and the residents on the properties.
Because it's driveway, as it is now, paved. Are there any, my question has to do
The
with
project
the
overall.
existing condition of the paved driveway, actually.
Yes, we have to look at the project overall. And what we do, the driveway definitely makes it safe. There are no issues, there are no negative issues with the driveway. The only thing that we would have to do is the drainage, because right now with the extra pavement, there's probably immeasurable, but there's extra runoff leaving the site than did previously. So we have to mitigate that runoff. So that's the only one potentially negative thing that we're proposing to mitigate if this were to be approved. Everything else is more positive.
Anyone else have any questions at this point?
If I had to summarize your hardship, it would be in that the non-asphalt, the gravel, was more of a hindrance to your clientele.
Yeah.
Perhaps a safety issue.
Well, I think they need to articulate it.
Well, they've said it, I'm just saying it for myself.
Yeah, you're summarizing it, and I agree. I mean, I also agree with Lori. I mean, we're not really claiming to have a hardship, and we don't need to. We need to have reductions, safety enhancements, and reductions of nonconformity, which this project overall does. Now that we're sitting here today and this has been built, there have been reductions in nonconformities, eliminations of this, and all of the safety enhancements as well. And before there was no mitigation of drainage or water quality either. Now with this water quality stormwater system, that will even be enhanced over what was there previously, together with everything else that we've already mentioned.
So Mr. Wren is saying that you don't need to have a hardship
I would
what
ask
does the
Attorney
text- What does
Capone.
our attorney say?
I mean, he's made an argument that I'm not a vote, right? I mean, I think he's made an argument, he's put forth, which I went back and I looked at his papers because I didn't recall in the application itself when you made sort of the initial statement about the exception, which, you know, I mean, there's very limited circumstances that applies to. I didn't see that in your application. So one thing you could do is allow him to augment his submission in writing, you know, and I know he's made a presentation with regard to why he's arguing that the hardship standard does apply. But it's not in your papers.
Pretty sure
You
it
made, you made not in the way that you've presented it. And look, I mean, you know, we are talking about the driveway. I don't think that the driveway itself was non-conforming in terms of its location or the condition, in terms of any requirements and zoning regulations. So, you know, again, you haven't heard that testimony. I don't know if there's a basis to claim that. That's again, not in the papers that have been submitted. So if the applicant wants to ask for an opportunity to submit additional information, that's one thing that could occur, I guess, in this issue. And I certainly, you know, I can give you, you know, in terms of some information, certainly share with the applicant as well, circumstances in which what he's arguing have come into play, so you know, can kind of see, but those are my thoughts. I don't know if staff has anything additional.
Do we bring up the application on here? Because I'm pretty sure since we had,
The accessibility wasn't really mentioned.
not the accessibility, that's not, you mentioned the
The non-conforming.
The non-conformity and the
In lieu of the
applicability of the hardship standard.
Yeah,
When you talk about the fact that
Application and joke.
But it
structure.
also, am I not correct in saying that this public testimony and this public hearing is equal to the application? Probably even better, because with the public.
Again, I just offer that to you
Yeah, no, I appreciate that, but
to help.
in my training and experience, that public testimony during a public hearing is equal to or better than what's written
you could
on
do a search.
a pre-application where we only have the ability to like write a paragraph. Especially we're finding on these online submittals, you get very limited area to.
Yeah, but you can always add an attachment. People
Explain.
put in a hardship statement and they just put it in a PDF. So you go
Here,
back.
right here. Explanation, no file.
So there wasn't one there. Okay, so if you want to go back to the details page.
Joe, if you see if you scroll down the attachment list, Joe, if you see it, to point it out for them.
Well, he mentioned it was in the box on the details page, so we're going to that.
In the property information section, the second paragraph says the pre-existing structure on the site was non-conforming to the northern side yard setback and was positioned very close to the property line. Additionally, a portion of the pre-existing driveway was paved and the remainder was compact processed aggregate as indicated in the site.
It's okay. Yeah, so that's what Joe, I think, was referring to, is the lines in the details page.
Yes, and third paragraph, we start to say there that the proposed and improved site plan, including new building and a crushed stone driveway, was conforming to all dimensional requirements of zoning regulation, long-standing northern setback conformity. Non-conformity was eliminated. If we scroll down more, we get into coverage percentages. And then the last statement just gets into this unusual set of circumstances and then requesting variance for coverage to retain the driveway and committed to providing a proper stormwater management system, and that's all in there as well. Pretty much everything that we have summarized. So this is project description. Was there a separate attachment for hardship?
We can look at that too. Yeah, newest to oldest, probably best. Probably be towards the bottom, because he moves. If you see it, Joe, just tell us
There
to
it is.
stop. Oh, okay, she's got it.
Yeah. That's where it was reading.
Yeah, so that's what we just had up. Right?
I think it was a copy of the details page.
Because the safer surface is the last thing that was mentioned. Above ground. That's what I read from it.
So that there's no other,
No,
same thing that we just read.
Yeah, you're looking for the explanation of.
Oh, right here. It's
That one says there's no file uploaded.
right here. So you see right there.
Yeah, there's no file attached to that.
And there's no other.
Right here.
It's further down in the same section.
Yeah, because that has no file with it.
No, it's further down, so.
Well, this one was the hardship. It said no file uploaded. So I'm not sure.
So if you, it's right here.
Under project description?
So if you go into the agenda itself, can you tap into it? Because I was able to pull it up.
The agenda.
You mean the hyperlink?
Yeah.
Because she's in the attachments
I'm
now.
actually in OpenGov in the
Yeah,
background.
which is what the hyperlink brings you
You
to.
try from the agenda itself to access it.
Okay.
I'd have to go back
It's
to.
similar. It's in there, and it's similar to the project description, but it does add some more about the surface.
Well, you make the safety argument at the end, which is kind of what I thought we were gonna hear more about.
Mhm.
Yeah, because that's a whole other, I mean, it's not really a Connecticut, but there's other jurisdictions.
Yeah, we've mentioned that. So the septic system is enhanced. It's code compliant. The drainage system will be better than before. The sight line was improved for site safety. The smooth surface is safer for all the clientele and anyone using that building. We've already gone through all of the safety pieces. This last paragraph here, not sure if it could be brought up on the screen, but it's here what I'm reading. In our opinion, the overall site condition has been substantially improved since the setback nonconformity was eliminated. All other dimensional zoning requirements have been met. A code compliant septic system was installed. Sight lines along High Street were improved to DOT standards. Additionally, the paved driveway provides a more manageable and safer surface for the residents and visitors of the facility.
We like to have public because we serve the public.
Thank you.
Does anyone else have any comments or questions that before we take any public testimony? Of course. Okay. Are there any members of the public? Thank you. Thank you. I'd like to, unless you have anything else, we'd like to get the public, any public testimony. Thank you very much.
My name is Jeff Cashman. I'd like to give you a little bit of information about paving.
Okay,
They live at 66 River Road.
Wait, are you speaking in favor of this application?
I'm speaking in favor, yeah. Wanted to remind each person in this
Excuse me,
town.
what is your name and address?
Jeff Cashman, 66 River Road.
Can you spell your first name for me? Can he spell?
It's Jeff.
Jeff. I'm sorry, I missed that. Okay.
Is this in favor of this or general discussion about paving? Is it in favor of the application?
Yeah, it's in favor, yeah. Snow plowing contractor for probably 45 years. one of the worst winters we've ever had in our lives for snow removal. We noticed the most damage to our roads this year. We watched just Waterside Lane this week get a repave. Okay, got a repave because of some cold temperatures and some other things that happen. If you've ever handled asphalt during December when you go to the plant, everybody's absolutely busy trying to fulfill contractual obligations to people that you are obligated by your contractor as a pavement contractor to perform because you need to get things done. You're under contractor's obligations for that. Normally in December, when people haul asphalt, they haul 30 to 40% more asphalt to keep it warm so that it's viable and warm for application in December time. We've always done that because of the traffic. You don't know who's in the pit. You don't know what's going on in that pit. When you're actually paving a piece of property, whether you're doing it by hand or a paving machine, you use a Tilcon. One of the biggest paving contractors had a failure in our town, Waterside Lane. When we have always done aprons on driveways because of aprons being done as a contractor, when we've always paved driveways, we've done repairs for curbing, we've done all kinds of asphalt work as a contractor in town. We have always added extra because it cools so fast. Watching curbs be broken this year, catch basins be destroyed, so much public work, we're watching them do a lot of commercial work this year to try and even protect our roads. When we look at a project that looks at this time, we look at and say the contractor showed up with too much asphalt. He was protecting your asphalt the very best that he possibly could to do the job he possibly could. And then when you have 20 or 30% more and you as a customer pay for it, what do we do when it actually went really well and we can get that asphalt down and we lay it out? That's probably what was a standard for every paving contractor in the world. Get it out of the box, get it out of the truck. It's December, we don't want it. That's a standard operating thing that every paving contractor does. How this happens, the driveway gets to be 6 inches too wide and they use that extra asphalt. I would have done the exact same thing as a paving contractor. So I'm supporting. I don't want to get stone in the middle of winter time.
Thank you, Mr. Cashman.
Thank you.
Are there any other members of the public who wish to speak in favor of this application? Is there any member of the public who wishes to speak in opposition to this application? Is there anyone who wants to speak generally or has any general questions about the application? Make any general comments? And now I would ask the applicant if you want to respond to the comments that Mr. Cashman made, or is there any response to the testimony that you heard?
Joe Wren, for the record, no, I thank you, Mr. Cashman. I think, from a paving contractor's direct experience, I've never paved driveway myself, so we appreciate that insight. I know that asphalt has to stay warm, but I never realized that they put 30% more on the truck to keep it at proper temperature. So it's a very valid point in the real world occurrence that happens very frequently, if not all the time. One thing before you decide to close the public hearing, though, I just wanted to, through chair, I just wanted to ask the town's attorney, because she talked about augmenting or supplementing the application. Is that something that needs to be done now that we went through that a little bit more, or something that we could write out now? Or what would you like to do with that?
So, look, I mean, that's not, I can't give you advice. I mean, I just kind of threw that out there because I felt that, to me, when I read the papers, I didn't really understand that you were making the argument that you did. Obviously, you did present it, and I don't disagree with you that it is in the record. Of course it's in the record, because your presentation is part of the record. I just didn't know, if you wanted to ask for an opportunity to submit something in writing that matches or supplements what you said. And that's the only reason why I raised it, was because I did recall, reading it and it clicking to me that I needed to even offer guidance to them with regard to that, because I didn't understand that was the hardship claim or not hardship, but the primary claim that you were making in support of the variance. variance.
Yes.
I did again sort of expect from reading, the last sentence of the explanation of the hardship that maybe you were going with safety. Right.
With both, thank you, and lots of times we are a little bit more clear and say, but it seems to get repetitive over time, to ZBA boards that in lieu of a hardship, working with reduction of nonconformity, sometimes we straight say that in black and white. We thought it was pretty clear here, we weren't really claiming hardship, so the only other thing you could claim is safety enhancements and reductions of nonconformity. So we didn't say there was no hardship, but we just figured that it was kind of, common sense. I mean, the hardship is more personal safety and having a smooth surface versus an uneven surface, loose surface. But it's not really like a land-based, your standard land-based hardship that we're all used to. Property's too narrow, we need to have a wider house, that type of thing. So it's not as cut and dry as that. So we thought we did a good job in describing it in there, but I think that with this intensive testimony that we provided, that supplementing the written paper copy, I think is, I'm comfortable with that as being adequate for the record to understand.
I'd like to address something with that. If an applicant wants to submit additional information, I don't believe it's our practice. Mr. Wren said if we could do something right now, I don't think that that's the route we should go. If he wants to submit something additional, we will not be able to close the public hearing, correct?
Correct. So it's a meeting management piece of providing time to write something into the record would be additional time. That's for the board would want to take a recess to grant that, or you could continue the public hearing and do that unless the applicant is essentially saying that they don't believe they need to add anything else into the record and the board can consider.
Do you think that you need to add anything else into the record?
I don't believe so, but I also don't want that to be a reason for anyone to vote against the application. So if the board feels that we need to write more than we did, speak more than we did, we're certainly open to that, and we'll follow the lead of the board for sure. Gilead is here because they've obviously spent more money in coming in to prepare this application. So if they've got continued another month, that wouldn't be ideal for them, but if it gave them an opportunity to get a more favorable response from the board, then I'm sure that they prefer to do that.
At this point, I'd like to ask the. What do you want to say to me?
I'm getting two different pieces, and I'd rather as you serve the board, certainly feels free.
Yeah, well, I think we've got to address this issue, and then that's additional. But
correct. So I think the conversation that we were having was relative to any potential conditional consideration. Should the board close the hearing, be prepared to act and go in that direction? And that's a separate piece. I think the thing that staff was advising on was the fundamentals of this. Of the ground coverage issue and whether or not the board would consider that variance independently from the stormwater piece, which is required regardless, right? If the variance were to be granted, stormwater is required. It's not, so the board's decision and considerations are, do you have enough information in the record to deliberate on the request for the variance itself, which is the ground coverage variance. I think the dedication to the stormwater piece is important. It is admirable. It is a good thing. It is also required.
So it's really up to the board whether the board members think that they have enough information.
That's sort of the question I had is, do you feel you have enough information? Is there anything else you would like to hear from the applicant? Is there anything else the applicant would like to put into the record?
I'd like to hear from board members as to whether or not each of you thinks that you need any information. I know what my position is, but I'd like to hear from everyone.
I have another question. So Mr. Cashman was not the vendor that put asphalt on.
No.
Just to be clear, I didn't think that was the case.
I'm glad you mentioned. I would assume that he would have identified himself as such, but
yeah. And the idea was, would there be a case that because they had so much asphalt, because that's a practice of that industry, that that's what happened? to your driveway, or is that, you're not contending anything like that?
It probably, if they had extra asphalt, yeah, they put it, they don't wanna take it back with them. So anything that came gets put down, so it did get.
That's
Because that
conjecture, right?
seems
That's
the
conjecture.
nature of,
That's conjecture on your part, right?
Honestly, they would have still been over. It wouldn't have been 50%, 15%, would have been over the 15%. We were asking for 21.2%, maybe it was 20%, 20.5%. We don't know that exact number. And that's not the reason. We're not saying it was more was paved than was planned. The entire area that was crushed stone, proposed crushed stone was paved.
yeah, I'm just trying to understand, like, the testimony of someone in favor of this. You know, how does that apply to this? You know, how is that?
Well, I think you mentioned other important things and reiterated other important things that we did about plowing a loose surface in the wintertime, creating an uneven surface during the wintertime, potholes, annual maintenance of a loose surface after plowing, after a hard winter like we had. I think he made other points in addition to the extra 30 or 40% asphalt on the truck. That's not the reason we're claiming that we're here in front of you. It's the whole piece. It's the 2,300 square feet, not maybe the extra 500 square feet that was added because of that. It's the whole piece. But he did make some other more valid, true, sense, practical points about a paved, solid, smooth surface versus a loose, uneven surface of stone.
Yeah, thank you. I just, you kind of want to understand.
Yes, no, good question.
Yeah, so, thank you.
The first one was good too, if he was actually paving contrast. But no, absolutely.
Does anyone else want to speak to whether or not you or she have enough information?
I have enough information.
I'm good.
Yeah, and I also, I have enough information to make a decision about whether the public hearing should be closed. But I haven't heard you say that you need to submit something else, and so I think we have enough.
No, I think the only thing to clarify, that the attorney asked be more clarified in writing, even though I think we're very, clear in stating our position that the basis to grant a hardship in this, or the grant the variance in this case, is due to all of the safety, and health enhancements on the property, the accessibility enhancements on the property, and also as a project as a whole overall, the reduction, the elimination of volume, significant house volume in the north yard setback that was completely eliminated. Yes, we've added a new nonconformity of coverage because of the residential driveway counting. So I think that in a nutshell summarizes everything that the attorney would have wanted to speak more in writing. So on the record, you have it in writing, and you have supplemental verbal testimony on record, on recording, for permanent record. It'll be in the permanent minutes as well, so I think that would suffice all the way through. Hopefully everyone agrees.
And is there anyone, any further comments from anyone in the public? It's your turn. Okay. And I think there's a consensus that we have enough information to at least close the public hearing.
Can I ask a question?
Yes.
Jennifer, I have a question for you as staff. If the stormwater situation is a condition of the that they're offering to do that, well, they have to do it, but for the variance to do, because that's coming in, how do we differentiate between that and new information closing public hearing?
I don't think that the variance would be conditional.
Yeah.
Right?
I think that we're advocating against that.
Right.
Because that was the proposal.
Yeah.
Right, but the board, when acting, can separate out those two issues, because in order to get the CO to be zoning compliant, to go through and to have demonstrated they are not increasing the volume of water leaving the site or treatment requirements, they still have to do that work. right? But the issue is they did not want to pay for that work ahead of knowing whether or not if the driveway is not approved, and they have to take it out anyway, and that engineering work isn't required. That's a large expense for Gilead to absorb for something that may be for naught. And so I think so they were waiting on that particular piece. So the board's deliberations should really focus only on the variance itself and not have a conditional approval. There could be findings surrounding the stormwater requirements, but the variance wouldn't necessarily be conditioned on compliance with other sections.
I also look at, we have two steps, right? We can have a vote on closing the public hearing, but then we can continue the deliberation.
Correct. Right. Correct.
And that's actually where I'm leaning. I think there's a consensus that we can at least, there's enough information, the board has to take a vote on closing the public hearing. So I will entertain a motion from one of the board members to close the public hearing.
I'll make the motion.
Is there a second?
I'll second.
Is there any further discussion?
If I don't want to if I don't want to close it, if I want to make a decision tonight, can I not agree with this motion?
Well,
You have to close the public hearing
Yeah, close
anyway.
Public hearing anyway before you make it.
Oh, okay.
Correct, is that correct?
Yeah.
Is there any further discussion? Motion to close the public hearing?
So it was made by,
Okay.
and seconded by Bruce.
There was a second.
Bruce.
And no further discussion. All in favor? Any opposed? Any abstain? All right, then the motion, the public hearing is closed, the motion carries. So now that the public hearing has been closed, we move on to the question of deliberation. As I just said previously, so I believe I had enough information, and apparently the board agrees that there's enough information to close the public hearing. I would like to continue the deliberations to give a little bit more thought and go a little bit more detail about some of the issues that came up tonight, and especially some of the discussion that we heard from the applicant that wasn't necessarily literally set forth in some of the papers. So I would want to continue. We have 65 days from today, is that correct, to reach decision. So we are under any time constraints in terms of if there's a decision to continue the deliberations to reach your meeting. So I'd like to hear from everybody else.
Yeah, I would be in favor of further deliberation. And just to clarify this point, we can reject the variance, and the applicant could apply again if they have a remedy to address the drainage, the water situation.
Well, if the variance itself were to be rejected, unless you reject it, I suppose, without prejudice, they would be subject to the board's impetus to reverse rule. So they would have to come in with a substantially different application, or something that's not the same thing that you previously opined on. So that would be important to think about.
So, I mean, you were saying, if I understand, that we can't make this like conditional, like in our decision, we either have to approve or not approve the variance.
You are evaluating the variance on its merits.
Right.
I can make a decision tonight.
So you are not in favor of continuing. Good.
I'm okay with continuing.
I could make a decision tonight.
So, I just, one thing too, it is fine for you to review the recording of the meeting too. So I do mention that if you do end up, continuing, because it does look like three of you are in favor of continuing the deliberation. It is fine for you to review the recording, and of course, the other records as well, or the other documents in the
So three You're in favor of continuing, right, so it is 3 to 1. It is the consensus is it 3 of us. So we need to have a vote on, we need to have a formal motion, correct? Okay. I will entertain a motion to continue deliberations on ZBA 26-3 until the next meeting of the regular meeting of the zoning board of appeals on
June
June
17th.
2026.
I'll second.
I'll entertain a motion.
I'll make the motion.
Is there a second?
I'll say.
Okay, any other further discussion other than what we've already had? All in favor? Aye. All opposed?
3 to 2.
Any abstains, any abstentions? All right, the motion to continue deliberations, carries.
Thank you.
Thank you.
Thank you.
You want me to quickly pause for election, but
Great, yeah.
do 5 minutes for.
Yeah, do I need a motion for that?
No.
Okay, we'll take a 5-minute break. Thank you.
Why stop the recording?
You can pause it.
Very sensitive. I don't know.
Yikes.
Thank you all for your patience. The next item is item 5C, ZBA 26-4, 32 Old Knob Road, Assessors Map 20/Block 6/Lot 57, Zone R60. Robert and Brianna Godsey, owners, Brianna Godsey appellant, Robert Godsey and Brianna Lucio, sorry, I mispronounced it, Lucio Godsey, property owners. Appeal of the April 2nd, 2026 cease and desist order issued by the zoning enforcement officer for violations to Town of Clinton planning and zoning regulations, sections 27.1.71, 12.53.3b, and 12.53.3, parens 1. Open public hearing, eligible for decision if the public hearing is closed. Very briefly, the steps that we will go through tonight is our zoning enforcement officer may read portions of or part of her CEO report into the record about reasons for the cease and desist order that was entered in this matter. The appellant will present the application. The town attorney may comment on the application. The board will ask questions, give comments, and then we will entertain public testimony in favor of this application, public testimony any in opposition, or any public testimony in general, neither pro nor against. Then we'll give the applicant a chance to respond to any of the comments or add any additional information. We'll ask if the board has any further questions. And then the board will decide if the public hearing, if we have enough information to close the public hearing tonight. So, Simona, did you want to make a short presentation?
Sure. So just to clarify, this is not an application, though it's an appeal.
I'm sorry.
Of my decision. So I did write a report, and I would like to read it into the record. I'm going to start sort of from the beginning of the enforcement. On April 2nd, 2026, in my capacity as zoning enforcement officer for the town of Clinton, I issued a cease and desist order to Robert and Brianna Godsey, property owners of 32 Old Knob Road, Clinton, Connecticut. The violations are as follows: excavating, grading, and removal of large amounts of material without planning and zoning commission permitting, per zoning regulation 27.1.71 in the R60 zone. Excavation or deposit of materials requires a special exception permit. Per zoning regulation 27.2.71 in the IP zone, excavation or deposit of materials requires a special exception permit. So this property is split into two zones, R60 and IP. Just so everyone knows what that means, R is residential, I is industrial. Per zoning regulation 12.53.3b, the excavation, grading, or removal shall be carried out in accordance with the maps and plans as approved by the commission. 12.53.3C, the excavation, grading, or removal shall not result in sharp declivities, pits, or depressions, or soil erosion. The stockpile of materials is located less than the required setback of 50 feet from the front property line. Per zoning regulation 12.53.31, the toe of slope for all stockpile materials shall be set 25 feet back from the side and rear property lines and 50 feet from the front property line. On March 19, 2026, in response to a complaint regarding activities at 32 Old Nod Road, I conducted an off-site inspection of the property. Through direct observation, I noticed a substantial amount of clear cutting in the southern portion of the parcel northeast of the residence. I also observed excavation activities being performed without any soil stabilization measures or sediment and erosion controls in place. Cut trees had been stockpiled adjacent to Old Nod Road within 50 feet of the front property line. I engaged in multiple conversations, both in person and through written communication with the Godsees on the following dates: January 14th, 2026, January 20th, 2026, January 27th, 2026, January 29th, 2026, February 6th, 2026, February 12th, 2026, February 24th, 2026, and February 25th, 2026. These discussions focused on their stated intention to conduct farming and logging activities at 32 Old Nod Road. During these interactions, I offered to assist the Godsees in navigating the process or applying for a special exception permit for farming use. As of the date of this report, they have not submitted any permit applications, nor have they provided a site plan identifying proposed activities or the locations of those activities on the property. During multiple conversations, Brianna Godsey asserted that the property held a PA 490 designation. A PA 490, which is also Public Act 490 designation, provides a use value assessment of land classified as either forest, farm, open space, or maritime heritage. It does not exempt a property owner from complying with the permitting requirements in the Town of Clinton zoning regulations. In a letter dated April 6, 2026, Town Assessor Donna Sempe confirmed that the PA 490 exemption for 32 Old Nod Road had been removed. She further stated that under state statute, a new application is required when ownership changes, and the property must be inspected to determine whether it continues to qualify under Public Act 490 guidelines. Applications must be filed between September 1 and October 31 to be considered for the upcoming grand list. Despite the issuance of the cease and desist order, clearcutting, excavation, grading, and stockpiling activities continued. On April 6, 2026, I drove past the property to take photographs from a public roadway vantage point. The Godsees subsequently contacted the Clinton Police Department and filed a harassment complaint related to this observation. During that visit, I observed that no sediment or erosion controls had been installed on the site and that disturbed soil remained completely unstabilized despite the ongoing clearing, excavation, and grading activities. On April 30th, 2026, I received a call from attorney Doug Dubitsky representing the Godsees, requesting that the Godsees move the cut trees away from the road and cut them into firewood. I emailed him on April 30th, 2026, stating that I did not give permission for this activity. I explained that the property is under a cease and desist order and no work should be done on the property until the enforcement matters have been resolved. On May 8th, 2026, I drove by the property because I had received phone calls that work was continuing on the property. I observed that the previously stockpiled trees adjacent to Old Nod Road had been moved and cut into firewood. Additional clearing appeared to have taken place, again in violation of the cease and desist order. And I had photos from my April 6, 2026 and May 8, 2026 site visits that I sent out in the email to the commission, but they're also posted on OpenGov. At
this point, I will ask the appellant to present their appeal. Is there someone here on behalf of the appellant?
Good evening, DBA. My name is Doug Dubitsky. I'm an attorney. I represent the Godsees. And we are looking for the board to find that the cease and desist order has been issued in error and to vacate it. I did not bring copies of the documents I'm going to be using. I figured I would make it very simple, and everything that I'm going to be discussing is already in your record. I'm not introducing anything that is not on your system. To start off with, I need to make very clear that this is only about zoning. This is not about wetlands. There's a lot of wetlands information in the record. There's wetlands minutes. There's a wetland cease and desist. This hearing is only about zoning. It is also not about forestry practices. Forestry practices are not something that this commission regulates, or even the zoning commission regulates. One thing before I finish with this, Madam Chair and Mr. Secretary, when you read the legal notice, you read it as 12.53.31, sub 1. It's actually sub L. It looks like a 1. It's understandable, but it is sub L. And that is actually pretty important because that is what the Godzies have been accused of violating. There is no sub 1. When we talk about violations, what we need to do is start with the cease and desist order. April 2nd is the date of the cease and desist order. So the cease and desist order claims that the Godzies were doing excavation, grading, and removal of large amounts of material without planning and zoning commission approval. The cease and desist order cites zoning regulation 27.1.71. That is excavation in a residential zone. There has been no excavation in the residential zone. This property is split. Part of it is in the residential zone. Part of it is in the IP industrial zone. Residential is R60. The only thing that has been conducted in the residential zone is forestry practices. Taking down trees and removing the stumps. That's it. Excavation under section 12.53.1 states no earth, loam, topsoil, gravel, clay, or stone shall be excavated and removed from any lot or graded or dumped on any lot except as authorized by these regulations or as authorized under a permit granted by the commission under the provisions of this section. Taking down trees does not fit in that definition. Even removing stumps does not fit in that definition. There has been no excavation in the residential zone. Cease and desist order is in error and should be vacated. There's also discussion about clear cutting. There's been no clear cutting. And even if there were, there's no provision that prevents clear cutting. Clear cutting is when you take down all the trees on a lot. They are selectively taking down trees to open up some area. There is no issue with that. That is not a violation of anything. But because the legal notice and the cease and desist only mention a violation of 27.1.71, which is excavation in a residential zone. Both the cease and desist order and the legal notice are in error. The section that deals with excavation in an industrial zone is 27.2.71. There's no mention of that in the cease and desist order or in the legal notice. Now, that should be the end of it. That should be enough right there to vacate the cease and desist order. But I'm going to address the work in the industrial zone anyway. The work in the industrial zone is the Godzies cleared an area. They removed less than 100 cubic yards of material. Most of it, they just moved away from the road, farther away from the road, and pushed it up a hill in order to open up a flat area where they could cut up their firewood. They burned firewood. We had a lousy winter. A lot of people burned firewood. I burned almost 6 cord this year in my own house. They have trees. They want to cut them up, split them, use them for firewood, and they needed a place to do that. So they pushed up less than 100 cubic yards. Now, 100 cubic yards is quite a bit of material. A full-size triaxle truck, dump truck, at absolute maximum is about 20 yards. Most of them run about 17, 18 yards. So you're talking about between 5 at the minimum, 6 to 7 triaxle loads in order to get 100 yards. They didn't remove anywhere near that amount or even move anywhere near that amount. So because they did not excavate more than 100 yards, even if the cease and desist order and the legal notice had been legally proper, under your regulations, they did not need to get any type of permit. Under section 12.53.2, there is a set of exclusions where it reads exclusions. The provisions of this section and the requirements to obtain a permit shall not apply in the following cases. C, third one is excavation and removal or grading of less than 100 cubic yards of material on any lot in any calendar year. Well, they did their excavation. They moved that material in 2025. So under your regulations, they could go and move 99.9 more yards of material this year and next year. That's what your regulation said. So even if the legal notice and the cease and desist cited to the right statute, to the right regulation in the right zone, they still haven't violated anything. Now, it is true that they should have given the CEO written notice before they moved that material. That is true. However, they did give, as the CEO mentioned, she was at the site a number of times, and they did talk about that material. They talked about what was done, and you know, once the material's moved, you can't give notice in advance once it's moved. So they didn't give the notice. That is true. The other statute that, I'm sorry, the other regulation that the cease and desist order claims the Godzies have violated is 12.53.3b. That's what's in the cease and desist order, which is excavation and grading or removal shall be carried out in accordance with the maps and plans as approved by the commission. All right, but because they were under 100 yards, under 12-53.2, they were exempt. The whole section does not apply. It specifically says the provisions of this section, which is 12-53, and the requirements to obtain a permit shall not apply if you move less than 100 yards, which they clearly did. Now, they're also accused in the cease and desist order of violating 12.53.3L. And this is where that's important that it's L and not 1, which is stockpiling of material. That subsection 12.53.3L is part of the excavation section. It's stockpiling earth, loam, topsoil, gravel, clay, or stone. There's no allegation that the Godzies did any of that. They're accused of stockpiling trees, logs. That's not, and is not covered by 12-53 at all. Even if the Godzies were subject to that and were not exempt because they did not move more than 100 yards, that section does not apply to stacking logs that you're going to cut for firewood to heat your house. It only applies to earth, loam, topsoil, gravel, clay, or stone. That doesn't apply. So those are the sections of the regulations that the cease and desist order claims that they violated, none of which are applicable. Now, as the ZEO mentioned, she filed a report. It was put on the system today. And she read it accurately into the record. That was the first time that we ever heard anything about section 27.2.71, which is excavation in an industrial zone. Wasn't in the cease and desist, wasn't in the legal notice. First time it appears is in this memo that was read into the record tonight. And in this memo that was read into the record tonight, there are several inaccurate statements. Including that despite the issuance of the cease and desist, clear cutting, excavation, and grading and stockpiling activities continued. That's false. As soon as the Godzies got that cease and desist order, they stopped. I asked the ZEO if they could move the logs away from the road. She said no. So they sit there as of today. She also said that they were moved and cut up into firewood. It's false. It's right there. Now, in support of those statements, the ZEO attached some photographs. She submitted them with her report. She submitted 2 sets of photographs. One was photos taken by CZEO K. Savona on May 8th, 2026 of cutting and grading activity on 32 Old Nod Road. Okay, so she's got 1, 2, 3, 4 photographs. 5 photographs, sorry. She's got 5 photographs. May 8th, right? And then she attaches 2 photographs that say photos taken by CZEO on April 6th, 2026 by CZEO K. Kavona at 32 Old Nod Road. Right? She's got 2 photos. 2 photos from the window of her car. The implication being that there's a difference between the April 6th photos and the May 8th photos. She's saying that the April 6th photos show wood on the ground and the May 8th photos don't. Therefore, the Godzies must have cut up that wood. Problem is, and remember, the cease and desist order dated April 2nd. So she's got photos from April 6th and May 8th. The implication being that if the wood is on the ground on April 6th and not on May 8th, then it's in violation of the cease and desist order. Here's the problem. These April 6th photos were actually taken on February 19th. 2 weeks before the cease and desist order was issued. How do I know? Because those two photographs are in the record on your computer system, dated February 19th. They're also attached to the April 2nd cease and desist order. These photos were not taken on April 6th. They were taken months before. They were taken before the cease and desist order was issued. 2 weeks. One of them shows Miss Godsey cutting wood on February 19th. And they continued to cut wood for 2 weeks until they received the cease and desist order. Yet, if you believe this report, you would think that she was cutting wood after the cease and desist order was issued. Cease and desist order and the legal notice are legally defective. Should be vacated. Godsey's haven't done anything wrong. Frankly, they should be left alone. I'd be glad to answer any questions.
You're looking at me. I do have a question, but I think the question should come first.
April 6th, that's the date.
I have some, but does anybody want to start with question? And then I give them all.
You had cited, section 12-53-3, L. And in reading that, it talks about stockpile of materials. I believe you were making reference to stones and rocks, and I don't see what that applied here. It's not even mentioned in that line.
It's within section 12-53, which is excavation, grading, and deposit of materials.
But this is under a section standards and requirements.
Right, standards and requirements of excavation, grading, and deposit of materials.
Okay, so where does the part about stones and rocks?
It's in 12-53-1.
Okay, thank you. Do we have copies of that cease and desist order?
Yes, everything's in the record.
We have copies here, hard copies.
Everything's in the, yeah, we can pull it up.
Yes.
You mentioned several times that any removal or cutting was less than 100 cubic yards.
Yes.
What evidence do you have, or have you ever presented to Ms. Savona that it's less than 100 cubic yards in 2025?
I have the, my clients have told me that, and there is no evidence that they are in violation of that. In order to remove 100 yards, you would need between 5 and 7, maybe 8 triaxle loads. they certainly know that they have not moved that much.
Well, I'm just asking, it's, your client told you that?
Yes.
No pictures were ever been presented to Ms. Savona, to the zoning enforcement officer of,
Pictures are hard to exemplify what the yardage is. Yardage is typically determined by loading it into trucks. Or measuring, or because when it's in the ground, it's packed, dirt compacts. And when you dig it up and you load it in a truck, typically that's when you measure it. There are times when you could, you could measure the square footage of the area, the height, the width, the depth. But they know how much material they removed, and it was less than 100 yards. And there isn't any evidence that it's more.
Wasn't this all used for firewood? Isn't this what the explanation was for the reason why they're cutting the trees down? And
correct.
So how many cords of wood did they remove?
Well, a lot of it is just stacked near the road right now because they haven't done anything with it.
Okay, if it's stacked by the road, you can't measure the amount of cords of wood that's there?
Well, the number of cords of wood.
It's a measurement.
How would that? Are you talking about how that relates to the amount of dirt that was removed?
No, I'm talking about the amount of wood that was.
I don't know that the amount of wood.
You were talking about the amount of wood that was stacked into a truck or a vehicle.
No. It's dirt.
Okay.
Soil.
But all right, but going back to my question, then, do you know how much wood was removed?
I don't.
Do they know how much wood was removed?
I imagine they could figure it out, but that's not in your regulations. That's not that is not one of the things that is cited as a violation. What's cited is stacking. And because it's being stacked, it was stacked by the road, it's still there.
Mm-hmm.
They would like to be able to take it away from the road. How much firewood they get out of it is not the subject of the cease and desist order.
I have a question. So you're suggesting that because the idea is that it's under 100 yards and under 100 yards isn't governable by the ZBA. How wouldn't the fact that it's within a setback matter, regardless of whether it's over or under 100 cubic yards?
It would if it were, but it is not. The material is 73 feet from the road. So there is no violation, even if the cease and desist accurately cited to the correct regulation and it was properly noticed, which it was not.
You did make a statement that regulation 27.1.71, I believe you said it was not in the cease and desist order, but it actually is in the cease and desist order.
No, ma'am, that's, I apologize, but that's what you heard.
I think it's
what I said was that 27.2.71 is not in the cease and desist order, which is the excavation in an industrial zone, where 27.1.71 is in the cease and desist order, and that is for excavation in a residential zone, and there is no excavation in residential. And I just, I see you've got that site plan. in your hand. You may have noticed that in the report, the ZEO indicated that no site plan had been filed. Board member O'Rourke has one in her hand, and it is in the system.
Madam Chair, please inquire of council whether or not, in fact, that's a site plan for the proposed work. That's a current site plan that's been submitted.
The current site plan has been submitted?
No, I said, could you please inquire of him
Whether,
as to whether or not he's representing that that is a current site plan?
are you representing that that is this work is calling as a current site plan?
That is a site plan of their proposed activities for the future. Yes.
Does it have, what is there a date on that site plan?
I can't read it, but it's in the,
I believe it was submitted about a month ago.
Madam Chair, could you please ask council when that site plan was prepared?
Yes, I did ask
I have,
if there was a
I
date.
really should correct it.
Okay, okay, but so as opposed to a date on the site plan, when it was prepared? Is there?
When it was prepared
All right, is
under
it,
seal.
okay, do you know when that, when that site plan that is being held by our member when that was prepared?
Yes, approximately a month ago, it was prepared in anticipation of a wetland commission hearing. And that's what it was submitted. And I assume, and it's only an assumption, I assume that the ZEO took that and from the wetland commission hearing and submitted it into the record of this board. But that was submitted to the wetland commission and
by whom?
By me.
it mentions the name Whiffen on here. Is that the preparer or the owner in the lower right corner?
No, I believe any of those, any of that would have been on the base drawing. There is a survey that that the Gozzi's have a copy of. I believe it's in the land records. They printed it out and drew on that. They did not have a separately prepared document by a architect or an engineer or surveyor. They took something that was already in existence and drew it.
So that's the answer to my question then, is that this was recorded on the land records. Prepared how long ago? I can't
No.
even read it quite frankly.
No, that's something that predates the Gozzi's. They found that in the land records and they took that as the perimeter of their property and they drew their site plan on it.
So they altered a document that was prepared in fact by the design professional.
No, they took it. It's done all the time. We took a survey and drew the areas on the survey that are identified there as where the various buildings are going to go, what areas are going to be where. They didn't misrepresent that document in any way. They
So
just
you're not representing the council, Nick, and I really should go through the chair and I apologize for that. Council should be asked whether or not he's representing that this is a site plan prepared for this project that's in compliance with the zoning regulations.
no, it is not.
Thank you.
Nor is one required.
Okay.
Is that document a part of this record in this
Right,
video?
right there.
Yes.
But that's pulled up.
Yeah, see, this is,
when I
the
can,
base
like-
document is a survey, an older survey, and these are the areas that were identified for various uses.
Okay, I'm going to ask this, at this point, I'm going to ask if staff have any comments.
I do.
Would you like to-
There's a few of them. First of all, this is not a proper plan. There's nothing on here. It's hand drawn with some numbers. There's nothing showing setbacks.
Can you say what you're referring to? when you
This
say
plan
this?
that's on our screen, I don't even know if there's a key that has, I can't read the legibility of who drew it. But
So,
the-
somehow
I'm sorry?
Please don't talk over each other.
Oh, this plan is not acceptable for zoning. First of all, there's no setbacks on it. We don't know what those numbers indicate. I never received any information defining how much yardage was removed. You can see from the photos I put up, that is not something I could tell by looking at, and I don't believe that the applicant can either. It was a tremendous amount out there that was done. This was completely cleared. There is grading that's been done. There's no soil stabilization, so it absolutely does fall under you have to have zoning approval for this. It has to, as a special exception. Secondly, there is no stabilization for it. The wood was left near the road. That's not a safe thing to do either. Thirdly, the part of the issue that the attorney brought up with the split zone, I never received a plan which shows where the zone R60 is or ends and where the IP begins or ends. And I would have needed a plan to show where the work was being done on each parcel, which was never received either. So you can't make blank judgment statements when I requested multiple times in multiple meetings with these people.
Please direct your statements to the.
Oh, I'm sorry. I'm sorry. To meet and discuss and offer guidance and offer help with, any type of, permitting that would be required. And the attorney is correct. This is not, there is a cease and desist in wetlands, but tonight's meeting is only about the zoning. But there are some overlaps in terms of some of the documentation. And that's why there may be some crisscrosses in emails and things in the record. And I apologize if that confused anyone, because he's correct. This is just for zoning. But so I completely disagree with a lot of the statements that he made on that. And according to our grading, and it's a special exception, it's under 12.53. It talks about the grades, the slope, all those things. I have nothing from any engineer to show me that any of that's in compliance. And for safety reasons, I'm concerned about the fact that it's not stabilized. And it's clearly, there's a tremendous amount here done. I could never figure that out, nor could they without an engineer giving us information. So to say that they did because of their word, they would need to have a professional to be able to confirm that. And this plan is not current. It doesn't show the grading. It doesn't show the removal. It doesn't show anything for the activities that are proposed or not proposed.
Jeremy, respond to that?
Yes, ma'am.
These are wood chips. They were brought here to stabilize this area when they received the cease and desist, so they stopped. Secondly, that plan, we didn't submit that plan for zoning,
What, that plan are you referring to?
the one that was on the screen.
Want to make sure we're talking about.
I didn't submit that to zoning. I don't know who did. I assume it was the ZEO. I submitted it to wetlands, so that's what they asked me for.
Actually, it was submitted by Brianna Godsey. It says it right here.
And it was submitted because it was required to be.
You can have a chance to speak.
No, she does.
Mr. Dubinsky is speaking.
Regardless, that was for, was that part of the application?
Mhm.
All right. I apologize. I apologize. I didn't submit it. The other thing, site plan description, the exclusion, the 100-yard exclusion specifically says that the provisions do not apply for less than 100 yards. So if you go out and you move a bucket full of earth Do you need to get an engineer to tell you how much dirt that was? No. How about 5 buckets? How about a pickup truck? No, you don't need to hire an engineer to tell you that you've got less than 100 yards. You've got less than 6 triaxle dump trucks full of dirt. So where's the line? At what point do your regulations mandate that a person spend money to go hire an engineer to tell them that they have not yet reached 6 triaxle full of dirt? It's not in the regulation.
Yes, I'm sorry, I didn't cut you off. Did you finish?
Yes.
Again, just going to answer your question about what documentation is there. You're receiving testimony from counsel. Now he's talking about a specific number of trucks. Is there documentation that 6 truckloads of material was taken off of this property? Why is he referring to a specific number? In my experience, typically, I mean, if material is being removed, there's some paper trail as to where it's going. Is there a paper trail with regard to the material that's been removed?
Is there a paper trail?
As far as I know, there is not, but when I use that number of 6 triaxles, I didn't say that's the amount that was removed. I said that's the amount that would add up to 100 yards.
Is that whose estimate? Yours?
No, it's pretty common knowledge that a triaxle truck loaded to the brim is 20 yards.
I wouldn't say that's common knowledge.
I'm sorry?
I wouldn't say that's common knowledge.
Okay, well, I will testify that a triaxle truck is about 20 yards, but you gotta load it real heavy. And typically, people don't like to drive around that heavy because, especially if the material is wet, they can get pulled over and they can get fined. So most drivers like to go with 16, 17 yards, maybe 18. So if you add that up, you've got somewhere between 5 trucks, which is full to the brim, or maybe 7 or 8 trucks, which are at a normal level.
Is this something you have expertise in? Have you know, because you're saying this is common knowledge. And I'm a pretty educated guy, but it's not common knowledge to me. What is your experience that you bring that you tell us this is, we have to accept this as a fact?
My personal experience is that I live on a farm and we get loads of chicken manure and other things all the time, and I have for 25 years. So I know lots about trucks.
Okay, great. At this point, not to change the subject, but it's 10:36, and this is later than most meetings go. And I personally think that this is the time that we should consider a motion to continue the public hearing because of the time. And
well, the problem is, if I may, problem is the Godzies are being prevented from using their land. And if this meeting is continued for another month, then there's another month when they can't use their land. They can't cut their firewood. And now is a great time to cut your wood for winter.
They can't use their land. That's a little bit of a broad statement, isn't it? They can't use how many acres, their land? I think we have protocol for meetings, Mr. Dubinsky, and this is one of the latest meetings that we've ever had, as far as I know. And I think that I would like to talk to the board about whether or not.
Well, the cease and desist.
Excuse me.
It's my understanding from the building custodian, the building needs to close at a certain time. And typically I received a text around 10:30, so I just.
10:30. Well, so that is what we have to go on, as far as I'm concerned.
Well, then I would ask.
Do other board members want to, find on it?
I agree.
I'm with you. I'm in agreement.
Did you, staff, did you?
It's based on my understanding of the custodian's hours, I can certainly.
I also think that the hour is late, and I don't think that we should rush through, and there are people who, it looks like they're, members of the public that want to testify, and I personally think that it's time that we should consider continuing this till next meeting.
When is the next meeting?
Next month,
June 17th.
we'll continue it to the next meeting.
Well, then I would ask
Well,
that
I
you,
would have to, well,
I would ask that you schedule a special meeting, because the Godzies should not be required to wait another month when the cease and desist order was legally defective.
that's your plan. Is there any, I don't know if there's any mechanism for, pausing anything until we go to the public hearing? Is it paused already because of force?
I'm gonna refer to council. on that.
There's not a mistake. So you have a request to hold a special meeting. What is the consensus of the board to entertain that? I mean, that's entirely up to you. And your availability and whether or not you're inclined to grant that request.
Do we have any, I can look at our rules. Do we have any rules about special meetings? Is it part of our board rules?
Things that might be posted appropriately, if you have the availability and we can get a room, we can certainly work with you to schedule one.
Staff.
I personally think that it should be continued until the next month, till the next regular meeting. It happens, we have had cases that have been continued. I don't think that there are circumstances that would warrant a special meeting, but we pass along. I mean, I'd like to hear what the board thinks.
I can appreciate the fact that perhaps there's a hardship for this particular applicant here. On his property, and I think I would entertain a special meeting. And wait 2 weeks for it.
Is there a legal requirement for notification to the
Just the posting of the agenda within the required time period. So it's not that you need to republish the hearing. No, that's not necessary once it's been properly published.
Any options to modify the cease and desist temporarily?
I'm not comfortable with that. I would defer to legal counsel though.
Listen, that's not my decision.
Yeah, I'm not comfortable with
You're
it.
the official
No.
authority.
I'm not comfortable with it. I mean, I firmly stand by my report and I feel the cease and desist is necessary. I've had no collaboration with the property owners to work with me at all, despite multiple attempts. So I'm very concerned about modifying that order.
Just so I understand the cease and desist, it applies to everything on their property. They're not allowed to do anything at all.
They have two cease and desist orders. One's for wetlands, this one's for zoning. So this is for that activity. So, I mean, they obviously have a house they can live in, they can do things on their property, but they can't do anything related to the violations.
Okay.
So it means the cutting, the grading, the excavating, the filling, the wood chips, any of that. They can't do any more of that type of work. But everything else is, I mean, if they live there and that's not a problem, they can do other things to their property, garden or whatever.
Do we take a vote? Should we take a vote on that? Okay.
And we should talk about dates, please, for our benefit. We're all valid. Dates of availability.
What are people's availability? And what are we talking about? 2 weeks?
We have to see if there's a room available too.
See if there's a room available, and then
And then the location could be in town hall, it could be at the police department community room, it could be up at the library, wherever there is sufficient space and the ability to hold a hearing, that we can be flexible on. So I'm just looking ahead at calendar dates. Can you pull your calendar? Because mine's not showing here right now.
Because we also have other meetings.
There are other meetings that are scheduled during this time frame. So in terms of staff availability and then council availability, we need to sort of take a look at that. So potential dates, in terms of getting notice out appropriately. So we're looking at potentially the 26th, 27th, 28th of May.
I'm not here on the 26th.
Not here the 26th, so the 27th or 28th of May.
28th is a
How
sidewalk.
much notice do we need?
28th is
How
not,
much
so
notice do we
27th.
need for a special meeting?
It's a notice and agenda of special meeting. It can be done the day before.
24 hours.
It's fine.
Yeah. Fine. So we can, that's why I'm kind of looking ahead to the dates that would work for 24 hours notice. Let's see. June 1st. 3rd.
I cannot do the 3rd. I do have another meeting.
And I can't do the first meeting.
Okay. The 4th, I am at a public hearing, but you don't. 4th could be an option.
So the 28th and the 4th.
Probably won't be here, but that's.
Well, you need to be here.
Or just would we have a quorum?
We have to have a quorum.
As long as we have a quorum, that's.
And we need to have staff availability, room availability, attorney availability.
And for the benefit of the appellants, you really want to make sure there's 5 seated members at that night, so it's important.
So it sounds like 28th is,
I can't do
The
that
one-
night. I have a white wetland site walk.
Unless it was to be at 7.
That would just be really. Already here.
What about
11 hours.
2nd and 3rd?
I believe we said, so the 1st. Can't do the 2nd. Kathy's not available on the 1st. 3rd. Not available.
And then that brings us to the week before.
And that brings us to the 4th.
sounds like the 17th.
Your other options would be the 9th, potentially. I have plenty of zoning, you don't need me.
Or
I won't get back.
Oh, right.
And I'm
As
at
long as
planning and
there's a
zoning.
quorum.
Yeah, so.
So that would be 8th, the 9th would be the other option. So the 4th or the 9th would be the 2.
I won't be there all the time.
It's on the 17th.
I didn't hear you. I'm just telling you what dates staff and the attorney would be available to assist with anybody who's available to hold the meeting.
I do have a planning and zoning commission on the 4th, but I can probably get coverage because it's far enough out. I'll ask it to be here before. The 4th, big one.
I'm fine with the 4th.
I'll be in the meeting.
That your chair could participate remotely. She's in fine. You could participate remotely.
That I won't be able to.
Yeah, I don't. Is it going to be 8 to 7? It's such a long day. We have to be here that week too.
So you would prefer the night saboteur?
I just think we should start at 7. But, did the members want a special meeting? Did you guys make a decision how many people?
I think it's a need for a special meeting, but
Yeah,
I'm early in Illinois, so.
No, I would prefer to stay to the standing meeting.
Me as well.
We do it, okay.
Okay.
Okay, we didn't finish, did we sort of?
No.
Went around.
I kind of felt that the applicant deserves a decision sooner than another month.
Well. So how many of us, just we get a consensus it is getting late? I wanna keep it, you wanna,
Yeah, well, the regular meeting.
this 3?
I'm kind of reading with Joe.
It's 3-2. I mean, it's 3-2. I think we should go with majority, but
Put it to a motion.
unless our council thinks that that's something we
It
should
is,
do.
it is not my decision. We're not here for it's not my decision.
It's not the way you. I have things I thought. Okay, is there any other discussion?
Yeah.
Is there any other discussion along the borders? Let's, first, so what do we get? Discussion.
Well, I'm just struggling that we're talking about the cease and desist.
Let's make sure that everybody's, I wanna make sure that the recording purposes that we're only one person talking at a time, and everybody.
I'm just saying, I'm just troubled that there was issues with the folks in the cease and desist that didn't seem to address it. There's an impact. So that's where I'm not clear. And maybe I'm wrong.
Well, I will entertain a motion to continue the public hearing until the next regular meeting. Is that a proper motion?
Sure.
And then if it passes, it passes. If it doesn't pass.
I'll make the motion.
Is there a second? I know we've discussed it, but is there any other discussion before we move up? All right, all those in favor of continuing the public hearing in this case, in this appeal until the next regular meeting of the zoning board of appeals on June 17th, 2026. All in favor?
Aye.
Aye. All opposed? And no abstentions apparently. So motion carries, passes 2. To continue to the regular.
What's the date?
It's
17th.
June
7 o'clock.
June 17th?
Yes.
Still need to go through this.
The rest of the agenda.
All right, we're almost done.
Thank you.
Okay. Item number 6, correspondence. I have none.
Julie's talking.
Okay.
No sidebar.
Item number 6, correspondence. I have none. Is there any correspondence that the staff needs to mention? No. I want to pay about to adjourn the meeting. Is there a second?
I'll second.
All in favor?
Aye.
All right, thank you.
And it's 10:51, the record. Thank you, everybody.
Yeah, thank you. Nice to meet you.